Your Lordships, kindly. Lord, serial list number 1, Your Lordship. Serial number 51. I never sought for any adjournment, but this time I was not feeling well, Lord. That's a request. I may have it by next week, Lord. Serial number 51. I never sought for any adjournment. All the time I was ready. But this time I was not feeling well today, my Lord.
51.
Please, my Lord.
Inform the other side.
Please, I will inform. I will inform, Lord. I will undertake. I will inform.
Request of plan counsel for the petitioner. This matter on 5th of March.
My lords, with my lord's permission, list number 2, seal number 6, which was yesterday, was listed today because my learned friend was not present. My lords, may fix a date in this matter. They've given a proposal. I don't think it would go ahead, my lords, because I have given my written proposal to them, but I don't know what their proposal is. They said reasonable visitation rights. Looks like this is heading downwards, my lord. So.
Petitioner, husband is they keep on changing. They keep on changing the proposal. Hence, we are unable to come to a conclusion that for settlement agreement.
We'll
Hence,
do one thing. We'll do next week on Tuesday, February 4th at 5 o'clock. That day we'll close this matter.
keep on changing their proposal. My interest is if they will refer to professional mediator so that we can find out what is needed for this.
We'll do that. We'll do that on the day.
Yes, Lord.
We'll do on 4th of February. Until such time, what was the arrangement?
My lords, was pick up on Saturday, drop the child back on Sunday.
The same arrangement, let it go on till 4th. List this matter on 4th at 5 o'clock. The party shall be present in the chambers. As per the earlier arrangement on Saturday and Sunday.
Friday to Sunday.
On Friday to Sunday, as per the earlier arrangement made by this court, the father can exercise the registration.
Great.
Yes.
Serial number 53, my lordship. The week time will be granted to file the synopsis, my lordship.
50?
53, my lordship.
Which one 53?
First is,
Mahesh and Company.
please,
OL.
the week time will be granted.
A week's time is required. Who appears in 53?
Lordship.
Petitioner OL.
Official liquidator.
63.
He seeks adjournment.
Respondent.
That's what I'm asking. You have no objection. Yes, list this matter on, at the request of non-counsel for the respondent, list this matter on 11th of March.
Serial list number 2, serial number 20, my lords.
Serial number?
20. List number 2.
Why again it is list 2? That is 2. Oh, because it is WPs. That's what they were wondering yesterday.
I am appearing for the petition, my lord. Senior is not feeling well.
Serial number?
20.
Siddhappa
Have you
BM.
informed the other side? It's not an excuse.
My lord.
When I specifically say inform and mention, why not that? Come back. Yes.
My lord, serial number 28, my lord. Other side already informed, I appear for petitioner, my lord. Next, any date, my lord, next week.
Why not today?
Today senior inconvenient is, sir. my
You are
lord. So,
ready for the rating.
yes, my lord, I appear. Other side, 28,
I'm for the respondent, my lord.
Yeah, I appear for the respondent. Lord.
In 28.
Yes, ma'am.
28.
20.
And we adjourn.
Yeah,
Yes.
adjournment.
Yes.
Any day after 7th, my lord.
I mean, March first week.
Well,
Last first
List
week.
this matter on 10th.
My lord,
Request for
serial,
the petitioner.
check.
Yes.
Lord.
Yes.
my lord, serial number 38, my lord, list 1. We are for the respondent in this case, my lord. The concerned authorities in this case, they have changed, my lords, and we have to take instructions from the party,
What concern authority?
the official liquidator, my lords. So we have to take instructions from the client.
We'll see this matter when it reaches.
Serial number 55, list number 1.
Yes.
Fresh time zone. Copy supply ಮಾಡಿದೀವಿ ಅದು ಇನ್ನೂ ಬಂದಿಲ್ಲ
55.
55.
List is only 54. List is only 54.
List number 2, serial number.
Serial number 46, my lord. Appearing for the respondent in this matter, my lords, I have informed the other side. Due to some personal emergency, senior is not available. Kindly seeks 2 weeks of time.
We will see all these matters, rent matters, I think. We'll see. If necessary, we'll adjourn. Yes, call the list.
List number 2, serial number 30.
List
First time 1 week for petition.
Serial number
30. List
30.
number 2.
13.
30. In list number 2, serial number 3. Rahmatullah Sharif for petitioner.
1 week time.
Why?
Senior Indian.
Hmm?
Senior is Indian.
You appear for whom?
Petitioner.
Have you informed the respondent?
C. Shankar Reddy.
No, I will. You have to inform or else will please inform and come. Yes, next.
List number 1, still number 22, my lords. Official liquidators matters. We need one week's time, my lords. They filed a statement of accounts. We need to get clarification from the concerned person, my lords, the respondent. Serial number 22.
These matters court will look into and then grant a chance. And all these, this rent matters, specifically they are listed. Yes,
List number 1.
yes.
Authored matter serial number 1.
It is
H.
446.
Mahadevan Oil.
Service is complete. The reason it was adjourned to today.
Why is it adjourned? The office objections. Yes,
Of service.
yes.
But I appear for the respondent number 3. My lord, it was brought to your lordship's attention, my lord, that there are in fact multiple revision petitions which are pending in respect of the dismissal of Order 7 Rule 11 applications by the trial court. My lord, the crux of the dispute arises out of contracts which provide for the courts in England to have jurisdiction. My lords, despite that, the suits were filed in Bangalore, and my lords, we took the objection that since the contracts provide for the English courts to have jurisdiction, it has to be tried there. The trial court takes a different view, my lord, and that matter is pending before this honorable court in civil revision petitions. My lord, in fact, if those civil revision petitions are allowed, this application therefore becomes infructuous.
If it is allowed, it is pending from 2015.
It has, my lords, because what happened?
Absolutely, there cannot be any difficulty for your client to come to appear before this court than before the civil court. Neither it is advantageous to him or disadvantageous to you.
Yes.
When the matters are pending before the High Court,
My lord.
all of you are before the High Court,
Yes.
it would be better.
My lord, of course, my lords. My lords,
And it is always like Order 7 Rule 11 petition, if you are successful before this court,
yes.
everything will go.
My lords, so my lords, there are two aspects, my lords, which I wanted to bring to your lordship's kind notice. My lord, this application is seeking two reliefs.
Yeah.
They are asking for this matter to be transferred before this honorable court, or for permission to prosecute or continue to prosecute the matter before the civil court. Now, as far as that second relief is concerned, my lord, Section 446 does not pose a bar at all. There is no statutory bar against them to prosecute the matter before the civil court, because what Section 446 prevents without permission of this honorable court is any proceedings against the company which is under liquidation. But a suit which is filed by the company under liquidation, my lord, Section 446 does not come in the way, does not prohibit prosecution. So therefore, as far as that aspect is concerned, there is no impediment for the liquidator to prosecute that matter before the civil court. In fact, they have not been doing anything in the civil court. My lord, the reason why I'm told that there is some delay in the revision petitions being heard is, my lords, when the matter was first called by this honorable court, my lord, the records were called for and the records apparently were not received. But I'm told that the records have now been received. My lords, if this matter can be deferred by 4 weeks, my lords, what we will do is we will have those revision petitions, my lords, moved as quickly as possible before this honorable court, before the roster bench. We will explain, my lord, that this matter is also pending before this honorable court. We will try and have that adjudicated as quickly as possible, so that, my lords, within 4 weeks' time, we can come back and report the progress or the outcome of that matter before
No,
this honorable court.
What I'm not able to understand is
My lord.
why the defendant respondent is very much contesting on this.
My lord, the reason is
It
this.
can be transferred to what is the great disadvantage?
My lords, I'll be very upfront about it. My lords, there are two aspects. One is, of course, the question of maintainability, which has to be decided by the CRP court.
Yes.
The second aspect, my lord, if for whatever reason, my lords, it is held that these petitions the suit is in fact maintainable, my lord, the nature of the allegations that are made in the suit will require a detailed factual scrutiny. Because my lords, it relates to the quality of the aircraft engines that have been supplied by the defendants to the plaintiff company. And my lords, these relate to the quality of engineering, the quality of supply, the questions of metallurgy come in. My lords, scientific experts will have to be called for, factual experts will have to be called for. So therefore, my lords, it cannot be dealt with by means of a summary proceeding because, my lords, it requires a detailed technical examination.
Company application, will it be decided in a summary manner? Company petition?
My lord, the suit, my lord, the suit. If the suit is transferred,
To this court, will the procedure be summary procedure?
my lord, it may not be, my lords, but the only question is, my lord, it requires it requires a detailed factual examination, my lord, and therefore, my lord.
In that case, none of the matters can be transferred to a company court. It should be pending in the civil court.
And, my lord, and that is the reason why, my lord, this honorable court has been conferred the discretion, my lord, where the question is purely on the basis of a contract debt, my lord, where it is admitted, etc. Those, of course, can be transferred.
The other day, he was arguing the matter.
My lord.
So you are at a better advantageous position as you are on your application, the winding up proceedings are initiated. And now, again, it's the very same company. Now they want to proceed with the suit. So you have a better case. Now, the only issue is,
My lord.
all those matters are transferred to High Court where the liquidation, the winding up proceedings and all have been taken place before the court. It would be advantageous for both of you.
I quite see that. I quite see that. But the only request I would make is, my lords, if this matter can be deferred for 4 weeks.
Because why I'm very particular is that
My lord.
I heard him for 1.5 hours.
My lord.
Yes, my lords.
So we should pass some order after wasting 1.5 hour judicial time. There should be some logical end to this application.
There should be, my lords. There should be, my lords. The only request I would make.
Let it be a part heard. Let it be a part
Keep it
heard.
right.
Make one.
This on, yes.
The only request again, none of the rights are being adjudicated, my lord. The request why I'm saying it
No,
should be
well,
allowed.
finally, what we are going to do is I made it very clear that 100% allow this application. Whatever time they're requesting, let them have for 4 weeks. We'll have it on March 10th.
I have no issues, my lord. The only thing is, my lord, the matters, we have about 3,000 matters pending in the company court, my lord. The matters which are heard and not decided, my lord, they keep taking up cause list item spaces, my lord. We are not able to list other matters which we require urgent orders because
I think it cannot be a request now. It's been happening.
My lord, I'm just saying this because this matter is heard in full, my lord. That's the only.
That's why I said it's a part-heard matter. And you don't have to argue.
Please.
Same, because I remember all the facts. This is matter on 10th of March.
Deeply.
The request of then calls for the respondent. Yes.
Deeply.
Number 2,
Yes.
40.
No, this is an application under section
Yes,
454.
Hmm.
Petitioner.
Where is the official liquidator in this?
No,
not.
Petitioner.
You are not there in this too.
I'm sorry.
Next matter, maybe you're referring to.
So filed a joint, my lord, the matter has been settled, my lords. The matter can be disposed of in terms of the settlement.
Where is that?
We have placed it before the court, not 29/11/2024. A one-time settlement was proposed and that was accepted, my lords. All the payments have been made under that and joint memo is filed, my lords.
Parties are there.
No, parties are not present, my lords. If required, my lords, we can keep them present.
Because when we're recording it, better this is present.
Please,
When?
kindly have it tomorrow, day after tomorrow, my lords. We'll keep it present.
Tomorrow.
Parties present.
My lord,
Serial number
serial number 1, my lord. I had filed a memo of service, my lord. Kindly that may be taken on record
And senior counsel is appearing for whom?
for all of the respondents.
All the respondents. And the first matter, as per the order passed for this court, the official liquidator has served the hand summons on the counsel appearing for the respondent defendant number. All. No, like he is representing one and another advocate is already on record.
I'll
Where
give
is
the
that?
numbers, my lord.
Give that.
Three.
Respondent number? Only one respondent is not served.
That is me, my lord, which is Kingfisher. Other than that, everyone he represents, my lord.
But give that proceeding sheet. Yes, sir. This court by order dated 23/1/2025. I directed the official liquidator to serve hand summons on respondent, on the advocate appearing for respondent number 4, 5, and 6 before the trial court. Accordingly, the hand summons was served and a memo is filed before this court. Hence, notice to respondent number 4, 5, and 6 is insufficient.
Grateful.
Yes.
Serial number 3,
Please, Lord, appear for the official liquidator.
Yeah.
My paper respond.
Lord, may I relay now? Kindly see the order dated 4/7/2024, Your Lordship.
ಅದು bailable warrant served.
Lord, the order dated 4/7/2024.
Please use the mic.
Lord, order dated 4/7/2024.
Hmm.
Lord, the learned counsel appearing for the respondent number 2 and 3 submit that they would rectify the defects of the statement of objections, statement of affairs, which are raised in the statement of affairs. And it is made it clear that in the light of the presence, in the light of the presence of the respondent number 2, only on the bailable warrant has been issued till such time, till for compliance of the,
Date is 4/1,
my Lord, 4/7/2024, Your Lordship.
1 minute.
Would Your Lordship get the word?
Hmm.
Lord, counsel appearing for the respondent number 2 and 3 submit that they would rectify the defects which are raised in the statement of office by next date of hearing. And it is made it clear that in the light of the presence of the respondent number 2, only on bailable warrant have been issued till such time the defects are rectified. The respondent number 2 to be present on the next date of hearing. However, affidavit to be filed within 3 days from today, along with the copies of the address proofs, contact details, email ID, and other proofs, Lord.
You appear for whom? Respondent number?
2.
So what happened after this?
I filed the affidavit and also statement of reply letter to the official liquidator.
When did you serve?
No, Lord, copies have not been served, Lord.
I filed the.
In
Did you
fact,
file?
22/7.
Is it there in the file?
in fact, it was in last occasion, my Lord, it was called twice, my Lord, nobody was represented.
On the last occasion?
Please, Your Lordship.
Serve a copy to me.
Then the counsel for the respondent number 1 to 3 shall supply the copy of the affidavit dated 22/7/2024 and memo dated 25/7/2024 on the on the official liquidator. That was what is the order on the last occasion. Again, today the same, then why did you not do it on the last occasion? It was on 5/12/2024 is the order.
Lord, this affidavit, there is a direction by this Honorable Court that affidavit should be supported with the present address, contact numbers, email ID and all, but it does not contain anything, Lord, whatever the
File a
learned
fresh
friend has
affidavit
given now.
Upperly.
Yes,
You will file a fresh affidavit.
And it is of the year,
how much
Lord.
time you require for that?
We have issued,
5/12/2024 is the order. Now you file some some affidavit without even disclosing all the details as ordered by this court.
I given the letter to the official liquidator office that acknowledgement I filed with the report on the 25/7/2024.
This 25?
25/7/2024.
This order is dated 5/12/2024. So how will you do something before this order?
As per 4/7/2024 other side.
No, not that. On 5/12/2024, learned counsel for the, the counsel for the official liquidator submits that he has not received the copy of the affidavit dated 22/7/2024 and memo dated 25/7/2024. Submission is placed on record. Learned counsel, the respondent number 1 to 3 permitted to supply the copy of the affidavit dated and memo dated so and so, the official liquidator. And what should contain in that affidavit is already mentioned in the order dated, what is that, 4/7?
4/7/24, Your Lordship.
4/7/2024. You have to furnish all your details, the present address and all. Did you do it?
On filed before the court on 22.
Do that.
Okay.
Now you say that in fresh affidavit, you give all the details, that Aadhaar card,
Do that.
every card. You're not given, that the old address, give new address. So you furnish fresh affidavit. That's the old.
He
address.
stated his address. Why
No,
do you
he-
say that it is
No,
not
we
stated?
need an address proof, my lord. With the address proof, my lord, either this one, Aadhaar card and all. They have to prove it because we cannot.
Where did the court say all that?
My
Let's
lord,
see.
it is there in the order dated 4/7/2024, my lord.
Let us look at it.
At the bottom. May I read, please, Lord? At the bottom of the order, Lord. However, affidavit to be filed within 3 days from today.
2024.
Please, Lord.
Hmm. Our affidavit to be filed within 3 days from today, along with copies of address proof, contact details, mail ID for service through electronic mode as well.
Humble submissions. Madam. He furnished the old address. He has to furnish the new address. To catch him also is very difficult. Yesterday, police went and catch him.
What is happening?
So he had to furnish
Then
new one.
when you're not complying with the orders of the court, we'll issue warrants so that your clients will be present before the court.
Maybe 3-4 days may be right.
Mm.
In spite of an order passed by this court on on 4/7/2024, the respondents 1 to 3,
1 and 4 are expired, 2 and 3.
respondents 2 and 3 have not furnished the address proof and the present address, the address, have not furnished the address, the contact details, and then counsel for the appearing for the respondents 2 and 3 seeks time for filing the same. Finally, list is matter on 6th of February. By the time, if the
Present.
same is not placed before the court, the
Obliged.
warrants will be issued
Obliged.
by serving it in advance to the official liquidator. Yes, next.
Chair number 4.
Obliged.
Not serial number 4, I appear for respondents number 1, 2, and 4 minutes.
Yes,
But on the last occasion, I had made a submission that respondents number 1 and 4 have passed away. And that submission has been taken on record. All pleadings have been completed as far as response number 1, 2, and 4 are concerned, minutes.
Well, 1 and 4 have been died, your lordship.
Number 4. My lord, this is an application under section 468. These proceedings are to seek books and records of the company which is in the possession of former management of the company prior to winding up, my lord.
yes.
With respect to, my lord, the submission that R1 and R4 are deceased, it is true, my lord. We are evaluating whether their presence of LRs are required in this matter or not, my lord. In few cases, we have taken a view that LRs may not be required because there is no claim against the estate of the deceased. We will examine this, my lord. Kindly have it for hearing, my lord, if necessary.
At the request of the official liquidator, this is matter on 20th of March.
With respect to respondent number 3, my lord, Mr. Vijay Mallya, on the last date, your lordship had ordered service of summons through email, my lord. We have filed a memo dated 28/1, my lord, noting that we have filed, we have served him through.
Regard to the address and all, that
Please.
he'll be.
Two things, my lord. If I may invite your attention to order dated 14/9, my lord.
But as for the address furnished, the registrar of companies, whether it is sent or not, is it the case?
No, my lord. This is respondent number 3, my lord, Vijay Mallya. He's been absconding and in UK since the time winding up.
Not taken issue notice to respondent number 3, returnable by 31/2025 is the order.
Please, my lord.
12/2024.
Please, my lord.
Oh.
If I may invite your attention to order dated
14?
14/9. Of the 14/9/2017, my lord.
Hmm. Yes.
If I may invite your attention to page number 2 of the order, my lord.
Yes.
As far as respondent number 3, Vijay Mallya is concerned, learned counsel for official liquidator has produced court envelope so and so. At the end, my lord, it is refused. I've sent it there. He has refused. It's a civil proceedings. If I may further invite your attention to order dated 7/11/2024, my lord.
Hmm. What steps you have to take again?
I've just sent the notice through email as well, my lord. The service may be held complete with respect to that respondent.
Because it's already the notice that is sent is returned where it's refused.
Refused, my lord. Refused is deemed service, my lord. Hence,
Then what is the necessity for another?
it is just noted that it is refused, my lord. The sufficiency of service is not noted, unfortunately, in that order. Hence, I'm just seeking for a class. In 2017 order, my lord. Order dated 14/9/2017.
The order dated 14/9/2017 reveals that the notice sent by the Ministry of Corporate Affairs, Government of India, to respondent number 3.
3, my lord.
3 on the London address within inverted commas 18-19 Cornwall Terrace, Regent's Park, London, NW1 4QP is returned with the remark refused. Accordingly, bailable warrants were issued. Thereafter, on 7/11/2024, Land Counsel for the official liquidator sought time to take steps. 2 weeks' time is granted to take steps, and if steps are taken, the court is directed to issue notice to respondent number 3, returnable by 12/12/2024. Land Counsel appearing for the official liquidator submits that.
In the order, my lord, 12/12, my lord, I've been specifically granted permission to serve through email. Hence, I've
Then on by order dated 12/12, the official liquidator was permitted to take steps for issuance of notice. Where do you get that?
last line of 12/12.
In addition to email, it is submitted that they have sent where is that memo?
28/1,
Memo
not
dated
yesterday's memo.
12/12/20.
28/1/25, my lord, yesterday's.
28.
Yeah. I'm tendering office copy, my lord, if court.
Not there.
There is one operational difficulty in this matter, my lord. The company pending branch is another building in the drugs control office. So when matters are adjourned by a week or a couple of days, my lord, it takes times for the file to be sent from here to that building and from there to back, my lord. So sometimes files are not put up and office objections not complied if it is an adjournment of a week.
The memo is filed.
This is office
States
copy of
that
them.
They have already sent the mail. They've sent the notice by way of mail. Dated 17/1/2025. And a copy of the mail is annexed to the memo. Considering the fact that already the notice that is sent through the Ministry of Corporate Affairs, Government of India on respondent number 3 is returned as refused, and further, already the mail is sent by the official liquidator as per the orders passed by this court. In that view of the matter, the notice to respondent number 3 is held sufficient.
Grateful, my lord. It may be posted for hearing on any convent.
Yes.
Serial number 5/23.
The office.
An office copy.
Yes.
Serial number 5.
Appearing for the respondent. My
My
lordship,
lord, 1 week adjournment, my senior is coming on my behalf. He is appearing next week.
What
He's not,
adjournment, how many times you will ask?
Same thing.
How many times you will ask adjournment?
Only once this time because senior is coming.
Who's senior?
He is
You are
not free this
You are
week.
party in person.
Yes. And now I'm appointing one senior, madam. On my behalf, he is coming and filing wakalat, 6th February.
He is party in person.
Yes,
Who is this Krutika Raghavan?
that's my lord.
Kritika Raghavan, I have,
You are the
because she is appearing for OL. All along against me, first respondent. And number 2 is,
Finally, we'll list this matter on 6th, no further adjournments. On that day, whether you are ready or not, court will look into the papers and pass orders. List this matter on 6th, finally, no further adjournments will be granted.
yes.
And the order will be passed on the merits of it.
Please, ma'am.
Yes.
6,
Yes.
number 6,
Refer.
the liquidator H.N. Vasudeva.
Lord, on behalf of accused number 2, I'm filing this affidavit with the proof of address. Accused number 1, my lord, met with an accident and he is undergone surgery on 28th. I'm filing his medical records. Producer. Third. On the affidavit. One. Medical records.
Submit monthly fees.
So he has furnished the details of accused number,
Two, my lord.
accused number 2. You appear for 1 to 3.
1 and 2, not sir.
I'm for 3, ma'am. Respondent number 3.
You appear for 1 and 2. 1 and 2 met with an accident. 2 has filed the affidavit. And when will 1 will file?
One, my lord, if they have, I think, another 1 or 2 weeks time. At least 2 weeks time so that he can file the affidavit.
We can give you these many documents, one affidavit. What is that? Yes, we'll grant him and some time for this one.
Well, it is only, my lord, defects are to be notified him long back. If he can rectify the
What about the
defects are rectified, my lord, then I will have.
for accused now? What about rectification of those defects?
So accused number 2 was handling all the accounts. Accused number 1 was handling entire accounts of the company. And he was in fact on the way that day. He met with an accident. So I wanted to back, my lord, to do that. Only requesting
How much time you require?
4 weeks time, my lord. Because he's been asked to be that until 18th.
And you'll rectify the,
That is a conversation I had with him. So he'll be able to provide all the information.
not the conversation, will record it. It has to be done within 4 weeks.
But he's been advised. Day after 18th of February, after the current 2 weeks time, he can be.
As for the he has not come up before this court earlier. Last week it has come up.
Last week he was absent.
Absent.
So where are the proceedings?
Well, 23, 125, there is
23rd, there was a direction given.
On 23/1/2025, finally this court had directed the matter to be listed today and made it clear that no further adjournments will be granted. And by the next date of hearing, respondent number 1 and 2 shall file an affidavit along with their present address and other particulars. Then counsel appearing for the respondent number 1 and 2 submits that the respondent number 1 met with an accident and he has undergone surgery and he filed the medical certificate in that regard. It is stated that as far as respondent number 2, that's accused number 2, is concerned, they've already filed an affidavit about with the with the details and the Aadhaar card. And when it comes to the first accused, it is submitted that as he is not keeping well and has undergone the surgery, if 4 weeks time is granted, and as he is the one who is taking care of the affairs or was taking care of the affairs of the company, he would be in a position to rectify the defects. And for filing the affidavit along with the address and other particulars along with the Aadhaar card, and also for rectifying the defects in the statement of affairs. Finally, 4 weeks time is requested.
19th February.
4 weeks time is, he requests, the council requests 4 weeks time. Considering all this, list this matter on 12th of March. List this matter on 12th of March.
My lord, R3, my lord.
An affidavit, 1 minute, an affidavit by R1, and also they shall rectify the defects in the statement of affairs. Yes.
R3,
Hmm.
filing
What is that?
application for recall warrant.
Huh?
Recall for available.
Everything will be done here in the court. How can it be?
Cell number 7.
Direction to disperse
It is paid yesterday, my lord. If your lordship recalls, last week there was a detailed hearing with respect to that BBMP dues matter, my lord.
Yes, yes.
This is not the same matter, my lord.
Hmm.
The dues, the nature of the dues are different, but the question of law is the same. The dues that are being claimed by the applicant are with respect to
Who is the applicant?
Mumbai International Airport, my lord. The dues are with respect to parking charges of an aircraft which was owned by company in liquidation. Here also we have done the same thing, my lord. If I may invite your attention to order dated.
Have they filed their objections?
They have filed, my lord. I have filed objections. I am the respondent in the matter.
Not here. When you have called for.
They have filed the claim, my lord.
Claims.
They have
filed the claims.
Please, my lord.
Hmm.
Here also we have split the claim into two parts, my lord. One stopping on the date of winding up, and one continuing till the aircraft was in the legal possession of the OL, my lord, till it was sold. So the amount that we have paid to them is for a period after winding up till sale. Whatever parking charges were incurred for parking the plane in Mumbai airport, that amounted to 3 odd crores, my lord. Those amounts we have paid. They have filed this application for a cumulative claim of 7 crores, which includes parking charges prior to winding up as well. So on the last occasion, my lord, the coordinate bench was pleased to hear the matter at length, and it has recorded the order. For the matters which for the charges that have accrued till winding up, they have filed a Form 66, which is pending adjudication by OL. For the matters for the charges which have been incurred post winding up till sale, we have already paid the amount. Actually, nothing survives further in this application. They want to confirm some receipts. That is why they are seeking time. We have paid them yesterday, the pending amounts.
Yesterday, I checked with client, amount was not received. So we'll verify. And again, there is a GST issue related to post winding up period also. So we'll sit with OL's thing and figure it out that how to go.
Then it needs to be adjourned.
Yes.
It can be disposed of as well in my submission, but
No, it's not to be, because we not chartered accountant, their OS auditor has given report saying that even pre-winding up period amount also to be payable to us. Because we preserve the aircraft in such a way, they could fetch good price.
That costs.
I'm ready for hearing on that if that's the hearing they will insist.
Just find it out whether this amount is been credited to.
The request of the applicant. This is matter on 11th of March.
Cell number 8. Cell number 8.
I represent the petitioner
If I may
counsel.
request,
Some problem.
may I request your lordships to have CA 362, my lord,
See?
362.
No, who's, Lords, I represent the appellant counsel, or petitioner counsel in this matter.
Yes.
But there are two applications. This one applications filed by us, but there's some inconvenience today, my lord. I want to come physically if it can. Lordships could take it up on Saturday, my lord, if it is not very inconvenient. What's our Saturday is a working day, my lord.
Saturday might not be possible. We'll
Monday.
take up on 6th.
But can it be, there's some income, I'm sorry, my lord. Either Wednesday or 5th, my lords, I'll be grateful.
Fifth.
Please,
My
great.
lord, 6th, 5th, it is inconvenient for me.
Then when is it convenient to you?
My lord, any Thursdays, my lord.
That's what he's saying. Thursday is inconvenient.
Thursday, there's some family issue that function is there, but therefore I have to plead some.
I'm ready today.
This is matter on 5th.
Great.
Till number 9.
The request of,
My lords,
for the application.
this is an application for recovery of arrears of rent. The matter now unfortunately went before the registrar CPC for evidence, but the short point of this dispute seems to be for that period between 1st of August 2017 to 29th of February 2020, we've not raised any invoices, so they have not paid. That seems to be the only issue for which they're trying to tender evidence now. There's one application filed by them seeking to substitute the director with another authorized representative. Now, we don't know who this representative is, whether he's fit to adduce evidence or not. But if it is only this limited aspect of us not having issued invoices in all other matters subject to their undertaking to pay within a specific time period, they don't seem to be disputing liability. They're only saying, if I can just refer to their memo, which was filed on the 12th of January, 2024.
There's nothing like 12th of January.
Do you have a copy?
There is a one on 15/4/2024 and then 9/4/2025, 9/1/2025, 7/1/2025. Which is the one?
My lords, if I may just pass along my copy because there seems to be some difference in the dates entered in their memo. This is their memo,
What
in
they
fact.
say in this
My lords, they say it is humbly submitted that respondent number 1 has,
interlocutory application for substitution of
Please,
authorized
my lords.
representative, that is one application.
correct, that is filed during the
The
course of
objection
evidence.
of the official liquidator to the CA.
That is filed, my lords.
Then,
That's
Then the next one is
CA 136 of 2020 is the application for recovery, my lords. I'm on it. The second subserial number 431 is the application for substitution.
it's not there. That application you're referring to is not there.
For the substitution, my lords, that would be their application.
No application in 2025 except what I have said. Pass on that.
I'll just furnish a copy of the memo, my lords, because it seems to be a very limited point of me not having raised invoices. If I undertake to raise it subject to them fixing a time period, perhaps it could be resolved rather than sitting through
You
the
have
rigors of
copy of it?
evidence. It is their memo, in fact. I've received it on the 11th of January.
Copies.
Do you have a copy of the memo, madam? Please.
On this, it says 12th of January, 24.
What is the CA number 431?
My lords, that is the application preferred by respondent number 1.
That is for complaints of objections, it is listed today.
Correct, that is her application, my lords.
Of the cost side, is this the substitution application for the AR to adduce the evidence? Finally, that may be allowed so that the matter may be concluded and we can conclude the matter. So it's only simple application for substitution of the AR.
My lord, that's precisely my submission, that this matter is going on in evidence to resolve a very simple issue of. I'm only saying I can't raise invoices.
What is the evidence for that?
Please, my lords, that is precisely.
You're also not disputing that you have not raised the invoice.
I've not raised it for the simple reason, my lords, I'll have to calculate GST and add it. If they don't.
True, that
Please.
it is not, it's an undisputed. fact.
Yes, and the
Then
due
what
is also
that is
admitted.
going on before the
Please, and in
CPC?
fact, the due is admitted in this very memo, which I'm trying to place with your lordships.
Huh?
The amount which is to be paid, that is only disputed, my lord. So to show that.
According to you, how much has to be paid?
We had filed a calculation, my lord. So there was only for certain period we have already paid and we are sought for to adjust the same thing in the.
What is their objection to that?
They have a calculation.
And what is the evidence that is going on before the CPC?
Filed the documents, whatever we document, whatever payment we have been made and whatever the adjustment has been made.
But she says that that's not the issue.
No, my lords, that's not the issue. In fact, I'll just pass along the copy of the memo.
Why all the memos and the, why are they not put up in the fund? Whenever it is, it should come to the fund. List is matter on 10th of March at the request of professional liquidator. Yes, please. 10.
10th
Great.
of March. Serial number 10.
My lords, if I may please mention serial number 8. Well, there was an interim order in CA number 388. That may please be extended.
Where were you?
Well, Mr. Senior Counsel appeared. Well,
Look at it.
Serial number 10, I appear for the.
Get to the next state of it.
much obliged, my lords.
My lord, serial number 10, I appear for the respondent. I have filed CA 8 of 2025 seeking for change of authorized representative. The application may kindly be allowed, my lord. I will ensure that the
May be
office of
allowed on
patrons are
costs, my
compliant.
lord,
May we allow?
on costs. It's a very old matter.
My lord, change of authorized representative. I've also produced the board resolution and the authorization letter.
Where is that again?
My lord, CA 8, my lord. CA 8 of 2025, please.
PA number 8 of 2025 is 5. And order 302, the CPC to change the authorized representative of the company. It stated that the applicant, that
The earlier authorized representative has resigned.
the earlier authorized representative is resigned. And now, when Mr. Rajesh Ram Shetty is appointed as the senior legal manager of the company. And an authorization letter is issued on 3/1/2025 to represent the company and says come up with this application. And then counsel appearing for the official liquidator submits that. There's a company petition of 1 of 2015. Now at this stage, they have filed this application.
My lord, 2021, my lord, company applications 21. COP was 2015, my lord. They filed the.
Petition is of COP as of 2015. And oppose the application. Considering the reasons stated, this CA number 8 of 2025 is allowed. And accordingly, they're permitted to change the authorized representative of the company in application number 297 of 2021.
Please, my lord, deeply obliged.
The necessary changes should be carried out.
Please, my lord.
Serial
Next
number
level.
11.
My lords, I have not received copies of this application, CA
For the applicant.
367.
I appear for the applicant. I pray for 2 weeks' time to do the compliance.
2 weeks time for
Complying, there are office objections raised.
office of objection shall be complied with within 2 weeks. This is matter on.
My lords, he may be directed to serve a copy on me.
And
Yes,
a
ma'am.
copy, the counsel for the applicant should serve a copy on the official liquidator. This is matter on 20th of March. Yes,
Serial number 12.
I appear for the applicant. I pray for 2 weeks' time for the compliance.
same order in this also. It's 13.
Serial number
Which
13.
date? May I, which date, lots? The date posted.
Same date. What is the date given in the earlier matter? March
'Much of
13?
Serial number 13.
Please, my lord, appear for the official liquidator.
My lord, I am appearing for the applicant. My lord, the company was in liquidation more than almost 34 years. And the properties are not sold, it's only leasehold property. I am the major shareholder and the director of the company. I come with an application, my lord, staying of the winding up order, my lord, and recalled. On the ground that, my lord, I already entered in a settlement with the KSFC and KSIDC, the secured creditor. The objection of the official liquidator, my lord, I am not given comprehensive scheme, my lord, how I am going to revive the company, my lord. If that's the case, my lord, I will file a proper application under section 391. This is under section 466, my lord. I will withdraw this application. I will file the scheme with the comprehensive scheme, my lord, with all the details. I am going to how the, with liberty, my lord, my lord.
This is CA number?
Serial number 7, my lord.
CA number 7 of 19 is filed to recalling the winding up order. The official liquidator has taken an objection that the applicant has not come up with a comprehensive scheme. Land counsel appearing for the applicant submits that they may be permitted to withdraw CA number 7 of 19 with the liberty to come up
Yes.
with an application.
With a proper scheme of
by-
arrangement.
By showing the proper scheme. Then counsel appearing for the official liquidator submits that they have no objection. Accordingly, CA number 7 of 19 is dismissed as withdrawn with the liberty to file an appropriate application with a comprehensive scheme.
Much obliged.
Accordingly, CA number so and so. Let's close. Yes.
Because in this, file an application in CA 365, Manoj.
Appearing as the amicus in this matter, as the amicus in this matter. There's a note that I placed on record on 18/11/2023. There are two questions, my lord, before this honorable court. This matter pertains to the Bharat Gold Mines Limited, which is generally known as KGF, my lord, in Kolar. This is the question of is before this honorable court. There's a long history, my lord. I've placed that on record. Substantial questions before your honorable court are twofold. One is whether the revival of this company is possible. Secondly, whether the workers are entitled to additional VRS. The second question, my lord, has been answered by a detailed order by this honorable court on 9th of May 2024, holding that the workers are entitled to additional benefits. So that part, my lord, there is a quietus as far as that is concerned.
We have already challenged. We have challenged this order.
Please, madam. But in so far as this honorable court is concerned, that matter is not pending anymore. The first matter, my lord, which is in regard to the revival of the project, that, my lord, is still before this honorable court. So there is a detailed note that I have placed on record, my lord. My lords, deem it fit, my lord, any date can be fixed. The matter can be heard on that.
Meanwhile, Manoj, we filed an application under CA 365 of 2024. The applicant is a public sector undertaking, Manoj, which had leased certain lands from the respondent BGML of about 1,109 acres, and they had established a manufacturing division for rail coach factories. Now, my lords, the government has taken a strategic decision, my lords, in accordance with BGML, and they've agreed, my lords, to release about 28.35 acres of the land. And BEML is directed to surrender the remaining 1,085 acres, my lords. If my lords may kindly see Annexure H at page 79.
In this case, Lord, I've already got a petition. Not for this, I have to file my objections. Regarding the rates, my Lord, what they prescribed is not proper.
My lords may kindly see Annexure H.
That's why,
page
Lord, I have to file my
79.
state objection in this case, Lord, then.
Annexure H, my lords, at page 79. The first point, my lords.
What is the page?
I may read, my lords, page 79. BGML is in principle agreement for sale of 28.35 acres of land at the rate of 6 lakhs per acre as per market value fixed by the Deputy Commissioner Kolar. The third point, my lords, where they've agreed that BEML may file an application in the Honorable Court where BGML closure application is pending for seeking permission to purchase BGML land on public interest. And the fifth one, my lords, may have relevance. After adjusting 1 crore advance paid to BGML from sale value of 28.35 acres of land at the rate of 6 lakhs per acre, remaining amount of 70 lakh 10,000 may be remitted as per the direction of the Honorable Court.
Your Lordship, I
About
can-
1,100 acres of land had been leased out in 2004, my lords. Only so far as this aspect, we have filed this application. On the main matter, my lords, that may continue, and that is not, this will not affect the main matter, my lords.
As far as this particular letter is concerned, Lord, they fixed some 28, I mean, how much you fixed this?
6 lakh as per the DC, my lord. The deputy.
One second. What particular the particular?
Appear for whom?
I'm appealing for the BGML, Bharat Gold Mines Limited. Let actually the per acre, my lord, is 50 lakhs it goes. My lord, this pittance, the amount of what they have fixed is pittance. I don't know how they have fixed, how they have collided with the DC and how they have fixed that is the question. My lord, regarding this aspect, my lord, I have to file the statement objection, then we will argue this matter. I want some little time.
Then counsel appearing for which respondent is Bharat Gold Mines?
Bharat Gold Mines Limited is the first respondent, my lord. I am the only respondent.
The request of my counsel, the respondent, list this matter on 4th of March for filing objections to this application.
Lord, one submission, please. On 16th of January 2021, my lord, this honorable court issued notice to the state government saying that if the question of revival has to be considered, they're indicating, my lord, that they stand. They stand is still not on record, my lord.
State has to make this submission.
2021.
It's already, state
has been made a party, the state of Karnataka.
second respondent.
No, my lord, not in this application, in the.
In the entire company application,
Yes,
The
company petition itself.
in
COP.
COP 180.
180, please, Lord.
In COP 180, in the company petition 180 of 2000, the state government shall file their statement before the court by the next date of year. You filed.
State.
Notice is already issued,
That's
ma'am.
what I'm saying. You file your statement by the next date of hearing.
Please, Lords.
Grateful,
Yes.
ma'am.
Much obliged.
Please.
Next.
Cell number 15.
I appear for the respondent. We have filed our memo of retirement, which may be taken on record.
Where is your memo of retirement?
I appear for secured creditor bank.
Appear for the original petition.
You appear for whom?
The applicant in CA 494 of 2017 and the respondent in COP 134 of 2009.
Company is already wound up, my lord. They filed an application seeking recall of the winding up order.
What that CA 494 of 17?
No, she says that they're filing the memo of retirement.
We filed it.
There is the memo of retirement.
Retaining for whom?
Devashish Mitra and Gallows. Applicant is CA 494 and respondent is CA.
A memo of retirement is filed, stating that the party has taken no objection on 18/1/2025. And along with the memo of retirement, also filed a copy of the no objection and the signature of the client on that. Accordingly, the counsel is permitted to retire from the case. And the registry is directed to print the name of the parties in the cause list. List this matter on March 3rd.
Cell number 16.
Kindly pass over your.
Pass over.
Lordship, I appear for the petitioner in this matter. Appear for the petitioner in this matter, it's a stamp duty matter.
Huh.
On the last
Yeah,
application, we,
Seeking pass over.
pass over, along with 18 also, 18 also, Miller.
Huh?
Kindly, 18 also, serial number 18.
16 and 18.
16 and 18. Oblige.
16, 18. Pass over, both the matters. Yes, 17.
17.
Appear for respondents. For respond number 5, my lord. My lord, the leasehold rights have been actioned to me with regard to the 14th floor, and that has been confirmed by this honorable court. Now the official liquidator want to cancel that on the reason that they are movable assets like chairs, tables, and furniture. I'm ready to purchase that also, my lord, because I need the premises very badly.
Came up
Vacate the
last week.
present office place.
This came up last week, my lord. Today it is only listed for consideration of prayer with respect to respondent number 2, where
CA
he,
number 385.
please, my lord,
Is on
appearing
what?
for the respondent number 2.
But what is CA number 385?
please, my lord. It
Yes,
is a CA, my lord, seeking to
The-
defer or cancel the
the-
auctioned leases in
Order dated 13 June 2024, passed in OLR 57 of 20.
And for respondent number 3 in CA 385, my lords.
the pleadings are not complete in this matter, my lord. The respondent number 3 and 4 are still have not filed objections. Hence, it was posted only today to consider claim of respondent number 2 who has no objections to the application. R3 and R4 have not filed
It is just
objections.
your application, 385.
Please, my lord, if I may invite your attention to last order, my lord, last week,
I've seen that.
please.
What is what is this application for?
My
What is
lord,
the relief?
we had conducted e-auction for the leasehold rights of certain commercial premises in the UB city, my lord. The court had granted us permission to conduct e-auction, my lord. E-auctions,
Come to your prayer. let me
please, my lord.
look at it.
My lords, I'm filing objections to the company application. A date may be fixed to argue on the application, my lord.
No problem.
You just understand
Here
what it is.
R5, we
first.
are urgent.
I'm on page 13, my lord.
Yes.
R5.
To permit the official liquidator to keep on hold any further action regarding the leasing of premises as per order dated 13/6/24 in OLR so and so in CA so and so, confirming the auction of leased premises till sale of movable assets as detailed in OLR so and so, except so and so. The reason why we are asking this, my lord, is that
For the respondents in this application.
the people who are
But-
highest bidders in the auction, my lord.
Or you're representing,
Respondent number 3 in the company application.
respondent number 3.
Your objections
You
are not.
also- you also purchased the.
Yes,
Not purchased, my lord. They have made a bid. They have participated in the bid. They are the highest bidders now, my lord.
No, 3.
All the respondents are highest bidders with respect to one or the other property, one or the other.
Want to auction that, the.
We don't-
mobiles,
full-
mobiles.
Mobiles you want to sell.
Please, my lord, and then,
Till such time you cannot be opposition to them.
please, my lord, that is the reason we've asked for deferment in this application. Simultaneously, in that OLR that we have mentioned, my lord, the valuation process of movables is under process, my lord. We will sell it soon. Because the timelines mentioned in the auction notice have been breached, we are seeking these further orders, my lord.
Your Honor, I'm appearing for respondent number 2.
Respondent number 2.
I want to make one submission. The auction was conducted in the month of March 2024. I have paid 9 lakhs in respect of 2 floors. I mean, I was a successful bidder for the 6th and the 10th floor. they have sought for a prayer to permit the official liquidator
To
to
return
return the
EMD.
EMD amount.
That is not
I would
permissible.
request that this court direct them to return the EMD amount for both the floors, because they have sought for an exception in respect of one floor, that is at prayer number 8, serial number 7 and 9.
Where is that?
Page number 13 of this CML, 1-3.
Yes.
The reason that they have sought for an exception is because
Permit
there
the
is no,
official liquidator to return the EMD amount as detailed in table given in para. To the
at prayer
successful
number
bidder.
A, my lord.
Yes.
They have sought for an except the premises at serial number 7 and 9. One of the serial numbers pertains to my floor. That is the 10th.
Versus 9.
6th and 10th. Seventh is serial number 7 pertains to floor number 10.
Hmm.
That they sought for an exception because there are no mobiles on that floor. But still, they have not executed a lease with me. I am no longer interested in the property, Your Honor. It's been more than a year. My deposit is stuck with them. My sublessee has gone away. Now, I just would request them to refund my EMD amount because I'm no longer interested in the two floors.
You want to refund it? Hmm.
But without the exception, Your Honor, because even for the 10th floor, I would request for a refund of the EMD.
I am for respond number 5, man.
7 and 9 is, 7 is 10th floor, 9 is 14th floor.
Yes, I'm not interested.
You're in?
6th and 10th. 6th there anyways, they've asked for a prayer to refund it. 10th, they have sought for an exception, but I'd request this court to include that as well.
1 minute, 4 and 7. That is 6th and 10th floor. That is respondent number?
2.
To respondent
Table
number 2.
space.
Oh,
I may
Then,
file a memo, Your Honor, here.
then what about you?
Madam, respond number 5, I appear.
1 minute, respondent number?
My lord, I'm filing my objections. For respondent number 3.
What are your objections?
My lord, I'm filing my objections. We seek time to argue on this application, my lord.
What is your stand?
What is your, you want refund or?
You want
My
a
lord, we
refund
don't
of EMD, or you want because you're not able to occupy the property, or what is your stand?
My lord, we don't want the EMD amount, my lords. We want the.
Yes.
You want to occupy the property?
Yes.
Hmm.
I appear for respond number 5, my lord. I am ready to purchase the movables, chairs, tables, furniture, whatever
Then
is.
you have to conduct the auction.
Yes, and the value, whatever is the value fixed by the official liquidator, we'll purchase it, but we need the premises very badly since I,
The auction finalized
last year, my lords, the confirmed by this honorable court on 16th, my lord.
on 16th.
On 13th June 2024, confirmed by this honorable court wide
Happening from there. to
OLR.
now?
Lord, we've been trying to sell the movable assets, my lord.
What did you do?
My lord, we've appointed a valuer, got valuation report, my lord. We are about to put them on sale, my lord.
It should be like.
Please, my lord,
first
I understand, my lord.
Sale, then the auction of.
Please, my
the
lord.
leasehold rights.
Please, my lord. There has been some error in preparing the list of
How much time the official liquidator requires?
My lord, we have already conducted. We have already given valuer the mandate to conduct the valuation. So my lord, these days it's very difficult to even find the valuers. We have been finding IBBI valuers. Now someone has agreed. We have given him a mandate letter. So we are proceeding as fast as we can.
As far as 5th respondent.
Yes, my lord.
5th respondent says whatever is the
Value.
furniture they are ready to buy. What
So
do you say on that?
yes, my lords, once the valuer reports come, they can participate in the bidding. That would be my first submission, my
No,
lords.
it is like, no, I mean, it could be any day, today, tomorrow, after 10 years. And what they will
Yes.
do?
My,
Their EMD is lying with you.
my lords, one submission I would like to make. My lord, 2 applications parallelly were filed by my office to sell the movables and to lease out these premises. The selling of movable application was disposed of after the lease
When
application.
was it? When was it disposed of?
My lord, it was disposed of 1 month back, the
Hmm.
selling of movables, but the lease thing was disposed of in March.
No, why did you file that application at?
My lord, that is my office's mistake, my lord. So I can't do witch hunting on my
But
predecessors.
ultimately, you just can't say that your mistake. What is their mistake?
There is no mistake of theirs, my lord. I have admitted in my application also.
No, that EMI amount, whatever they want, you have no objection that you will give that EMI.
Yes, my
EMD
lords, I'll
amount.
pay them the EMD amount. Whoever wants it back, I am ready to pay within a week
Hmm.
or as fast as I.
Next one. What about respondent number 5?
My lords,
Should be some strict timeline. You just can't say whenever.
my
it is
lords,
done.
there is already a timeline. We are not able to find the valuers, my lord. We have found one. Now he's going to value. We have already given him a mandate. So my lords, we are going to come out with a sale notice regarding the same.
When?
My lord, as soon as the valuer values, I'm going to be on my toes to tell him to value as fast.
Something like it takes 1 week, 2 weeks, 3 weeks, 4 weeks.
A timeline may be fixed.
My lords, the matter may be kept on the next date. I'll come up with a fixed timeline regarding the same.
And now, as far as the 6th floor and 10th floor is concerned, on an order can be passed.
Order can be passed, my lord. And my lords, there are my lord, there were other floors which were empty or were already occupied. They have given a better proposal than what was auctioned. The floor was
want to
auctioned at.
Go ahead with that.
If in case someone proposes more than what was the auctioned amount, then my lord, I'll put it up before the Honorable High Court. There are some people who are interested. I'll put all the application.
So now, as far as the.
The EMD will be
the
returned.
Second respondent in.
I'll
will
return the
pass on.
EMD this week itself, my lord. I mean, it will take 2-3 days for processing.
The respondent number 2. A number 385 of 2024
Yeah, official toward.
submits that he has participated and is declared as a successful bidder in the auction for lease conducted with the petitioner, conducted with the official liquidator in respect of 6th and 10th floor of the, it's a 10th floor of Canberra Block, UB Towers, UB City, 24 Vittal Mandya Road, Bangalore, pursuant to the e-auction notice for lease issued on 19/3/2024. And the petition, the second respondent had paid an amount of rupees 9,80,000 as earnest money deposit. It is stated that there has been an inordinate delay in executing the lease deed and handing over the possession of the said floors. It is stated now the present application is filed for selling the movables.
For deferring the confirmation of lease till movables are sold.
For deferring the confirmation till the movables are sold, and it would take further time and it would be further delayed. As such, it's prayed that the second respondent prays the court to for a direction to the official liquidator to refund the earnest money deposit at the earliest. In this regard, they have already issued 2 notices to the official liquidator dated 27/9/2024 and 25/11/2024. The official liquidator submits that. There is no, they're also ready to return the earnest money deposit.
In fact,
line-
that is my alternate prayer B, my lord, in the.
And even it's alternative prayer in the application also. And they are ready to return the amount, and it is submitted that within a period of 1 week from today, they'll be returning the EMD. Considering the submission of the council appearing for the official liquidator and official liquidator, the official liquidator shall return the EMD in respect of 6th and 10th floor. That is a serial number 4 and 7 of the list that is placed before this court. The application within a period of 1 week from the date of receipt of the copy of the order. Yes, what about you?
Hello, sir.
My
File my
lord,
objection.
in
For
that.
the copy as well, date fixed to argue on the application.
No, what he says is, like, we'll have this next week. By that time, we'll come up with a strict timeline when it will happen. And you can argue as far as his. case is
Respond number
concerned.
5, I'm ready to purchase the movables well.
This is matter. Then the next, that's a no, next order. The official liquidator submits that. By the next date of hearing, they'll be able to come out with a timeline when they'll be able to complete the sale process. This is matter on 6th of February.
My lord, in the last line of the order, my lord, the EMD refund is only with respect to respondent number 2, my lord.
Respondent number 2, I said the serial
6,
number.
I appreciate, my lord,
The
please.
10th floors also, I have mentioned. Yes.
What's your list? Okay.
Serial number 18 pass over, serial number 19. Vivekananda S.
I appear for the petitioner, my lords. This is a petition relating to scheme of amalgamation, my lords. The scheme has been allowed. Lords, this relates to payment of stamp duty, my lords. In fact, we have also filed an affidavit indicating the stamp duty to be paid. Subsequently, we realized that two properties.
You're ready?
Yes, my lord. Otherwise, afternoon, another 2 matters. Subsequently, 2021 also, my lord.
All the stamp matters in the afternoon.
Much obliged.
Obliged.
20 pass over. 22.
Here for the respondent number 1, my lords. Seek a week's time, my lords. The Office of the Official Liquidator has shared a memo of calculation, my lords, for unpaid rents.
It came up on the last occasion.
It did, my lords. It
On
came up
Saturday, my
on
lords.
Saturday. This is
Let's
a
see,
matter.
let's see this. Do the file.
Last Saturday.
Official liquidator submits that as on today, the total outstanding amount is 2,59,000. Detailed calculation of the same of the court with the shall get instructions in this regard. The council placed before this court that correct line or date by which they're going to pay the amount.
Because we've been paying the amounts, my lords, previously also. This is.
Or this outstanding of 2
We
lakhs.
have, that's what, my lords. I have already conveyed this particular, I've shared this document, my lords. We need time to clarify, confirm, and then, my lords, if so, make the payment, my lords. May I kindly have it next week? I'll place it on record before the honorable court.
Finally,
Obliged.
at the request of counsel for the counsel for the applicant, let's just matter. on-
Respondent number 1, my lords. I am for the respondent number
Oh,
1.
applicant is official liquidator.
Please.
Respondent number 1 by 6, no
Obliged.
further time will be granted.
Great.
Obliged.
Serial number 23.
This is also an application for recovery of rental arrears, my lord. The
Okay, I
council
was
on the last.
directed to take instructions on this 20 lakhs on current dues. According to us, the entire amount is paid. I'll just hand this over to my learned friend. What the calculation that they had filed did not take into account the payment that was made for January 2025, as well as the TDS. Enclosed the entire set of TDS certificates.
Look into that.
I've enclosed TDS certificates from April 23.
Has placed before this court the calculation stating that, in fact, they have cleared all the arrears, nothing to be.
Current dues.
Current dues and nothing to be paid. And he has served the copy of the same on the official liquidator. At the request of official liquidator, this is matter on 6th.
Great.
There's one, insofar as the interest component is concerned, you know,
We'll look into that. All these now without interest.
Please.
You are looking, whether interest has to be levied or not, we'll decide it
Very
at
well.
a later point.
Serial number
Great.
24.
This is also for recovery of rental arrears, my lords.
Bye.
Lords, I pray for 2 weeks' time, Lords. I'll get further instruction. I'll give
2 weeks,
instruction.
why 2 weeks for?
Lords, I'm given to understand.
No, my lords, the dues are substantial. This runs into close to 3 crores 32 lakhs.
No, it is about the payment is a different aspect. First of all, whether that's the amount or not, what is your stand on that? That you have to come.
Last time when it was listed, my lords, I was given to understand that there was some understanding and that paid the current dues. So that is the understanding. I've been trying to contact the client. He's not reachable, my lords. In fact, from last night, I've been trying to reach him. I do not have any information. So that's the reason I'm seeking an adjournment.
I can furnish a copy of my memo of calculations, my lord.
Yes.
I have it ready.
Do you give me a copy?
My lords may also refer to the order dated 19th of April 2023. On that particular date, my lord, they've undertaken to appear before the OL and reconcile the amounts. This was
Long back.
nearly
Well,
2 years ago.
No, I'm given to understand that they
Purely
did,
to your-
Lords, my humble submission is, I had given instructions. I had also furnished a copy of the order to the client. And I was informed that they had visited the OL's office. This is the information that I have.
No, my lords,
Not. So
Then-
the court cannot wait for your client to come to the
Your
court
Lordships may
or
kindly
give instructions.
post
Let
it next
this
week.
Will this matter next week? And by that time, if there is
If
no
the-
response
If
from
the
the
memo could
client,
probably be given, my lords, I will also get clarification on that.
I have furnished a copy of the
the
calculations.
council appearance official liquidator submits that the outstanding rents are running into
3 crores
32
32
3
lakhs.
crores
32 lakhs, my lords.
32 lakhs. Then council for the respondent submits that. He'll get instructions. This court on 19/4/2023 has recorded that that as per the instructions of the respondent, that his client will participate in the proceedings before the official liquidator, as and when the official liquidator sends a notice. The first respondent through its counsel is put to notice to appear before the official liquidator on 3/5/2023. If he fails to appear, its version cannot be accepted by the court on the next date of hearing. It is submitted by the counsel for the official liquidator that the respondent has not appeared. Finally, list this matter on the 6th of February, and by that time, if there are no, the instructions, by that time, if there are no instructions from the respondent to the counsel, then the court will take appropriate steps.
Much obliged.
Six. Next.
25.
My lords, identical matter, and a similar order was passed again on the 19th of April 2023, where they had undertaken to appear.
Where is the counsel?
Appearing for respondent number 2, your lordship.
I'm asking about one. Where is the counsel, Mr. Rudresh? No representation.
No representation, my
On
lords.
behalf of the respondent. List this matter on 6.
Grateful.
Cell number 26.
Also appear for respondent number 8 in this matter.
Six in this matter. But I invite your attention to memo of service dated 11/6/24, my lord, with respect to respondent number 5.
How many are served? How many are not served?
1, 3, and 7 are yet to be served, my lord. The others have been served. I am requesting for noting for R5 to be served today. If I may invite your attention to order dated 35/24, my lord.
The memo is filed stating that as per the directions of this court dated 35/2024, the official liquidator has sent notice to respondent number 5 to email and WhatsApp as per the available records on 3/6/2024. And they've attached the email and also a screenshot of the WhatsApp for this court, where the WhatsApp screenshot shows that the WhatsApp is delivered. And also, the mail copy is placed before the court. In view of the same, notice to R5 is insufficient. Then,
My lord, for 1, 3, and 7, my lord. The service was taken, my lord. I understand there is some deficit in the court fee that I'll
it's
pay.
stated that the needful will be done in respect of
1, 3, and
respondents 1, 3, and 7.
please, my lord. This may be posted on the same day as serial number 4, my lord.
When is it posted?
I think 23.
This is matter on
23.
23rd or
20th March.
20th March.
It's also a 468 matter, my lord, hence the
But
request.
they've already received all the books from the CBI, my lord, where all the accounts were given. They already have the books of accounts and everything, my lord.
My lord, if I may invite your attention to order dated 35/24, my lord. That submission is already made. What has happened in this case, my lord, there is an obligation on the former management to file books on records and to give statement of affairs. In the matter, my lord, before winding up order, several documents had been seized by the CBI. Their defense so far was that CBI has documents and we cannot give. The OL has taken steps in the CBI court to retrieve copy documents of the documents that are seized, my lord. The Honorable CBI court has been pleased to give that order, my lord. The documents are now in a pile, my lord. It is, I am told, a truck's worth of file, literally, my lord. The direction in the order dated 35/24 is to the respondents to come and inventarize and tell us what is where, my lord. That also, a date was
That was
fixed, which
complied, my
was
lord. We appeared
let me
before-
complete, sir. You have made a submission. I am responding
Please,
to it.
please.
by order dated 35, my lord. The date of meeting was fixed by this court for the respondents to mark attendance before the official liquidator and to assist in inventorizing the file secured from CBI, my lord. Other than, my lord, R6, none of the respondents were present on that day, my lord.
We'll see. on the
My lord,
next
I'm
one.
appearing for R6, my lord. I appeared before the OL, my lord. I clearly stated with the memo.
See on the
Yes.
next.
Because I appear for R8. With respect to that order, my lords, I had also sent an email to the OL's office saying that there was a personal inconvenience. I couldn't not be able to present.
Yes, yes, next part.
Serial number
Obliged.
27.
I appear for the respondent in this matter, my lords.
My lords, this is an application for recovery of arrears of rent. The
My lords,
current
my understanding is that
outstanding would be about 97,53,115.
I will seek instructions on this, my lords, because as of June
Is
or
it
July
coming up for the first
2021,
time?
my understanding is that all amounts were paid.
Is it coming up for the first time?
No, my lords.
My lords, the last time it had come
The
up.
summons was served way back in 2021.
And when did you file that memo of calculation?
My lords, they filed their objections on 16th of March 2021 itself. And the memo, of course, is as on date. The previous calculations were given up to the date of the last hearing. I have calculations up to current date. And as on today, it's about 97,53,000 that remains in due.
My lords, if I may request the applicant counsel to furnish a copy of the memo, I will seek instructions from my client on this.
Very well.
The counsel for the official liquidator submits that as on today, the outstanding is 97 lakhs and dot.
53, yes.
97 lakhs and dot. And they'll furnish the copy of the same to the counsel appearing for the respondent. The counsel for the respondent shall get specific instruction on the timeline when they are going to pay the outstanding by the next date of hearing. List is on 6th.
My lords, they may just indicate their email ID so that I can serve it as.
To the official liquidator, your email ID.
Please, my lords, will share it.
Yes.
Much obliged.
Serial number 28.
My lords, this is also for recovery of arrears of rent.
Respondent in this matter, my lord.
This runs into about 8 crores, 57 lakhs and odd.
My lord, that's exactly my case, my lord. There is a lot of dispute here with respect to the invoices, firstly, and secondly, with the quantum of the claim that they have claimed. We have also gone to the OL's office and there is a dispute, and a dispute also has been raised, my lord, through an arbitral notice with respect to the demands and the calculation that they have furnished.
That is one aspect.
Yes, my lord.
What has been raised by them.
Yes.
No, according to you, what is the admitted rent? What are the dues?
My lord, I will seek instructions and a date may be given. I will file a memo of calculation.
By the next date of hearing. you
Yes,
file a
ma'am.
memo before this court.
Yes, my lord.
What is the admitted rent according to you and what are the admitted dues?
Yes, my
Are
lord.
you going to pay that amount?
Yes, my lord, because
Then whatever they are raising and whatever there is a arbitrable dispute or anything, any evidence is required, we will see.
yes, my lord.
Now, as far as admitted rents are concerned,
Yes, my lord.
what are that? You come up with a memo.
Yes, my lord.
And counsel appearing for the official liquidator.
But I
for
may
this,
get about 4 weeks' time, my lord. Because I need to contact, it's been a while, my lord.
My lords, these dues are
4 weeks,
pending
let
from
them give their
2016.
calculation. Let them give their,
Come up, you have an obligation to pay the money.
I am not running away, my lord. I am not running. Lot of circumstances also are there which need to be considered.
My lords,
I need at least 4 weeks' time, my lord. 4 weeks' time, my lord.
My lords, may I submit something?
Yes, why it should be 4 weeks? It's a CEO of 2020.
My lord, just to, there are a lot of factors, my lord. I will not evade the responsibility at all. I am just asking for time so that I come up with a actual and factual figure, which I feel that I have to pay, my lord, apart from the disputed.
Some amount needs to be paid. You can't enjoy the property just like that.
No, I have already vacated. I am not in possession, my lord.
He's not in position.
My lords, on 9th January, my lord, I'll take 1 minute.
I am not in possession.
My lord, on 14th of October, I served them a notice. My lord, they are the second highest.
15th October.
October 2024, I served them a notice as per the lease agreement that within 15 days you pay the dues or treat this as eviction notice. Otherwise, your utility services will not be maintained. Now, my lord, what happens is they don't pay the dues. I extend the time till 7th, 12th. I keep on giving time and their representatives keep on coming to my office saying, sir, we'll pay, please give us time and all that. Now, my lord, finally, we have to take the step. Utility services are stopped. Now, my lord, it is 14th of November. Now, my lord, their MD, Mr. Kalra, I don't know the full, I don't remember. Mr. Zorawar Kalra comes specially from Delhi and says, sir, we know we have to pay these dues. Just give us some time, we'll come up with a payment plan. Now, by buying time, my lords, finally what they do is they send us an arbitration notice. When the matter is already pending from 2020 in this Honorable High Court, for the current dues, we gave them a notice on 14th October. Now they send us an arbitration notice, which we refuted. We replied to it. Now, my lords, on 9th of Jan, their lease period was over. Neither Prestige was interested in continuing them, neither we were interested in continuing them. So, my lords, now they are not there. So, my lords, they are the second highest debtors with respect to rent, my lords. And this is without interest. And my lord, this client doesn't pay. They pay at their own will. Whenever they feel like they'll pay something, and we are not even able to keep our accounts on what this payment relates to and all. So the worst tenant we have had, my lord, sorry to say. And now they keep buying time, my lords. 2 months they have come to my office regularly. We'll give a payment plan, payment. Again, the same thing, my lords, 4 weeks. And this calculation sheets have been given to their MD, their representatives, and everyone, my lords. Out of trust, they are coming, I'm giving them the sheet. Now, again, they are asking for instructions and sheet, my lords, we'll again give it. But my lords, they don't deserve any sympathies from our side, at least.
My lord, my only representation here is the very fact that I've been going to the OL's office and trying to take time to see what is there and also not running away from my responsibility of paying the rent is very clear, my lord. Now that
File your objections to the CA?
no, we haven't filed, my lord, because there was a memo of calculation which we wanted to put, and this matter has not come up before the court. My lord, what has happened here is, it is not only the rent. My relationship with the landlord is also on a revenue sharing basis, plus a minimum rent has been calculated, my lord. I am a restaurateur. I am not a retail outlet, my lord. During the COVID, we were closed. Lot of issues were there, my lord. All I am asking from this court right now, your lordship, is that I need
When did
some.
you file your wakalat?
I filed my wakalat in the last date of hearing in 2021. It was mentioned that a memo of calculation should be given. After that, we have approached the OL. There is another matter also before this court, which is.
When they have filed an application, it's your duty to file your.
Yes,
your
my lord. Yes, my
response,
lord.
but your objections
Yes,
to
my
that.
lord. Yes,
If
my
you're
lord.
not filing objection, then it means you don't have any objection to that application.
No, my lord. I do have an objection, but at the same time, we've been trying to go and solve this matter with them after post the liquidation, my lord.
Where is your question of solving it from 21 to 25? So
I will file along with my memo of calculation, my lord. I may be given some time, my lord. Just
4 weeks. Not 4 weeks. I want you to get instructions on your admitted amounts by the next date of hearing.
my lord, 19th at least, my lord. 19th of Feb. 19th, 20th of Feb, my lord. At least till then, my lord. I
List
just
this
need
matter-
19th, 20th of Feb, my lord.
List this matter on 20th of February. By
Yes,
this
my
time,
lord.
the respondent shall come up before this court, the admitted rents according to them, as he is disputing the calculation that is based by the
R1,
this
my lord.
court by the official liquidator. It is submitted by the official liquidator that the first respondent has to pay an amount of rupees 9 crores. Huh?
Course 57 lakhs.
8 crores 57 lakhs. And though this application is filed in the year 2020, and till now they have not filed their objections, have not filed their objections, and they approached the official liquidator several times, and they were giving the particulars. And recently they have served with a notice that there is an that it has to be that there is an arbitral
Notice calling for.
arbitral notice is given to the official liquidator.
Which the official liquidator disputes, my lords, that it's not an arbitrable dispute.
It is submitted that when the matter is pending before this court, right from the year 2020, and without filing any objections, not only with an intention to delay these, protract the proceedings, such a notice is issued. Next para. The application is filed in the year 2020, and the respondent number 1 had notice of this, And right from in the year 2020, in the year 2021, and when a wakalat is filed, even till today, they have not filed any objections except stating that they have been pursuing the matter with the official liquidator. If the official, according to the official liquidator, if it is 8 crores and all, and according to them, what is the admitted amount and what is the amount they are disputing? If they ought to have filed those objections before this court by this time. There appears to be though it is stated that they want to pay the money and there are bona fides on their part, which this court is not able to find from the conduct of the first respondent. List this matter on 19th of February. By that time, the respondent shall come up before this court with his statement of objections and also what is the admitted amount according to him and the timeline to pay the said admitted amounts.
Number 29.
My lord, serial number 29 and 30, I appear for the applicant. My lord, I'm seeking a short accommodation. Some office objections have to be complied with, my lord. I'll have the needful done today itself.
May I invite your attention to order dated 12/7/23, my lord. The applications are not served on us for a year and a half, my lord, 2 years.
Now also.
Lord,
Not served, my
applications
lord,
were
and they
served
have
on 12/7.
submitted that the applications are served in 23, my lord.
My lord, I'll just verify. I'm told objections have, copies have been served. Nonetheless, I'll serve him today
The
itself.
office objections shall be complied with within 2 weeks and the copies of these applications shall be served on the official liquidator. This is matters on 18th of March.
My lord,
Great.
copies to be served within a day, my lord. It has been 1.5 years, my lord.
Yes.
I'll do it today itself, ma'am.
Serial
Great.
number 30.
My lord, 30 is a connected matter to 29. Same order.
Same order.
20th of March.
31st.
20th of
31.
23. 20.
Serial number 20th of March. Serial number 31.
My lord, this is also for
Appearing for the
recovery
respondent,
of
my lord.
rent.
My lord, a short accommodation is paid. My lord will furnish a detailed
Was it
response.
listed on the last occasion?
My lord, this was not listed on the last
What is
occasion.
the amount?
This is 12,29,000.
12 lakhs was the calculation served on them?
The
No, my
latest
lord.
calculation has been served on them. My instructions are it has been served on them.
I'll have to verify, my lord. I'll just
You have to
verify the same.
verify and you have to get instructions.
Yes,
And
my
by the
lord.
next date of hearing, I want to know when are you going to pay the amounts, admitted amounts?
Yes, my lord. Indeed, my lord.
According the council appearing with official liquidator submits that an amount of rupees 12
lakhs 29,000.
12 lakhs 29,000 is due from the respondent. And the calculation memo is also served on them. Then counsel for the respondent submits that they'll get instructions, list this matter next on 6th. And by that time, the respondent shall come up with specific instructions. What is the amount due according to them? When are they going to clear the dues?
Much
Even
obliged, my lord.
if no instructions are placed, the court will pass appropriate orders, basically considering the material on record. Next 32.
Much obliged, my lord.
My lords, 32 is also for recovery of arrears. They've paid us up to 31st of March 2021. They have vacated sometime November 2023. So the period between March 21 to 23 is what has to be paid. That comes up to 10 lakhs 24,000 approximately.
Your Honor, appear for the respondent. Your Honor, the respondent herein had filed another CA, which is CA 390 of 2022, and an order came to be passed on that.
My lords, if I may just provide some context, that's an application where they sought to pay it in 12 equated monthly installments for debts due up to 31st of March. Those sums I'm saying I've received. I'm saying post 31st of March 2021, they continue to be in occupation and
Get
vacated.
instructions on that and get instructions on that.
All right, Your Honor.
I'm
2
giving
weeks'
her a
time.
copy of
This is till March.
March 2021. From 21
2021, what they're asking is between March and November.
November 2023. So for almost 2 years.
The council appearing the official liquidator submits that the rents are due from March 2021 to
November 23.
November 2023. And the amount is an amount of, the outstanding is 10 lakh
24,000.
24,000. Land counsel appearing for the respondent shall get specific instruction.
Memo of calculation.
And also, and the memo of calculation is also served on the respondent, and they shall get specific instructions. And if any objections shall file, and the admitted amounts, and also placed before this court, when they are going to pay the admitted amounts.
All right, Your Honor.
Yes, next. Same, next,
6-2.
next.
Serial number 33.
Rent recovery application again, my lords. The outstanding is
respondent in this case.
1 crore 11 lakhs odd.
In this case, we didn't receive the rent bills from March 2017 to December 2021. And October 21, they sent us a notice. So this is the balance 1 crore 11 lakhs to 2,854. So calculating the interest also, they have given the rents.
That's fair. Forget about the interest. Whatever are the actuals, what you are
Well,
bound to pay.
the thing is, I have to get instructions from my client, then how we have to pay anyhow, but how much amount?
So you also accept that they have not.
Yeah, we
paid
have
the
to pay.
invoice. That's why you have not paid. And now they have, now they have said that they have covered, they have calculated with interest. Forget about the interest. First of all, whatever is the amount that you are supposed to pay.
Yes, sir.
Those
Yes, ma'am.
months that you come up with a calculation.
Yes,
And
ma'am.
tell the court what is the timeline you're
Can I have
required
the-
for payment.
Please, I've finished
Oh.
the calculation.
You're with interest or without interest?
Without, my lords. All of these
No,
are
no,
without.
without
It's only on the principal.
May I have,
The
may I get
council-
2 weeks time to get
The
it?
council of official liquidator had has placed before this court the calculation, that is the outstanding memo.
Presently, our bank accounts are also frozen, so that is why I need some
Memo,
2
one
weeks
memo,
time.
Memo. Memo showing the outstanding amount from,
My lords, this outstanding would be from, I'll just provide the exact date. I'll furnish a copy to the court as well, my lords. My lords, the entire period for which we've calculated is February 2017 to July 2021.
right there. 21, and then council appearing for the respondent submits that as no invoice was raised, they have not paid the amount. Now they've come up, they've issued a notice and also came up with the calculation along with the interest. Then the council for the official liquidator submits the calculation that now they have placed before the, passed on to the respondent is without interest and only the actuals as per the directions of this court. The list is matter on, when is that other matter?
No, this is the only matter.
19th, or what is the date given?
The cafe matter was on the 20th, if I'm not wrong. my lords.
I think 19th it is.
19th, very well then.
Yes, ma'am.
List is matter on 19th. By the time, the respondent shall come up with the what is the actual outstanding amount and when they are going to pay the amount.
Yes, ma'am.
Serial number 34.
My lords, this had come up last week, my lords. It's a very small sum of 54,900 rupees and they have not been appearing in the matter. Of course, there have been some communications issued to us where they admit the debt, but there's none representing them. It's just 54,911 without interest.
No notice is served, there's no representation. This matter on 26th of March, next 35.
35.
My lord, this is also for recovery of
And
arrears.
first
It had
respondent.
come up on the last occasion. Memo was furnished on Saturday to the learned
Memo
counsel.
of calculation as per the first respondent.
Take that.
According to the first respondent, lots, only a sum of rupees 6,10,489 is due.
According to them, how much it was?
That is around,
My lord,
without
it-
considering even the
Around a
COVID
crore,
period
my
has been
lord.
included in
Around
that,
a crore,
According to you, 1 crore, according to them,
this 6 lakhs.
is 6 lakhs.
that 1 crore is along with interest.
No, my lord,
No,
it's
my
only
lord,
the
this is
principal.
with
How
respect,
come there can be such?
discrepancy is, the COVID period has also been included in
My
the
lords, if I
statement which has
even
been-
consider the COVID waiver, it would still come up to 86 lakhs.
I have furnished the complete details of the statements. Let them reconcile, my lords.
Will pass over,
Very well, my
look
lords.
at it. Yes, next.
Number 36.
My lords, if I may just submit, there is a different accounts team which handles the ledger of this particular company. If I may request your lordships to have it next week, by such time we'll arrive.
This is matter on 6th,
Grateful.
at the request of the OL.
Cell number
Yes, 36.
37,
30?
7.
36, madam.
36 is on 6-2.
Hmm?
Next. 35 is passed over, 36 on next week you are seeking.
No, my lords, 35 in fact is what I asked
Ask
for.
for 35,
six.
the matter is already over. 36 you call.
My lords, 36, I have received instructions to appear for respondent number 1. My lords, give me 2 weeks time, I'll file my objections.
35 is adjourned. 36 you call. Yes.
36 my lords have recently received instructions to appear for respondent number 1, which is the company. My lords, give me 2 weeks time, I'll file my
My
objections.
lords, it's a 2020 matter. The company was
How much
served.
is the money
My
outstanding?
lords, the outstanding is approximately 97 lakhs.
By next week, get instructions. We'll see what is to be done.
My lords, can I have a member of calculations? That has
The-
not been given.
The council, the official liquidator has given the memo of calculation to the council preparing for the respondent. And as per the calculation, the outstanding amount is
97 lakhs, my lords.
97 lakhs and odd or 97 lakhs?
97 lakhs and odd.
97 lakhs and odd. The council for the respondent shall get specific instructions. And what is outstanding and when are they going to pay the amount? Same 6th.
Much of
6-2. Cell number 37,
My lords, here, the outstanding is approximately 2 lakhs and odd,
Who is the respondent not appearing?
not appearing.
Can you will see this matter on 26th of March? No, no wakalat is filed on behalf of the respondent.
cell number 38,
Appearing for the respondent, my lords.
The outstanding here, my lords, is about 2 crores 28 lakhs and odd.
My lords, we have to take instruction from the client, my lords.
You take who's job due from?
No, my lords,
I furnished the memo.
Same order in this also. The outstanding is 2 lakh,
2 crores, my lords, 2 crores 28 lakhs.
28 lakhs, same next week, 6.
19.
my lords, we have to take instructions from the client, my lords.
We
The-
take instructions, we'll
No,
see on
no, my
next.
lords, the concerned officers regarding the company, they have changed, my lord. So I have to take instructions.
Whatever, it's for the company, officers may come and go, companies,
Companies.
they have to get. They have to give you instructions
6-2.
and they will, if they don't, and it's their problem. Yes, 39.
So serial number 39,
My lords, here the outstanding as on date is 1 crore 80 lakhs. I'm giving the learned counsel a copy of the memo.
I pray for a 2 weeks time to file my statement of objections, my lord. In fact, it is ready. I am taken a defense of limitation, my lord, because most of the invoices are barred by limitation. So I will file my statement of objections and make my submissions, my lord. 2 weeks, my lord.
When did you file your wakalat?
I filed it somewhere in 23 January or February. my lord.
Who stopped you from?
No, in
filing
fact,
it?
my lord, the statement is ready, my lord. It has somehow the client, we have to just call them for a meeting.
PC has to be applied.
Yes, my lord.
My lords may refer to the order dated 12th July 2023. On 12th July 2023, they've sought a week's time to file objections. Till date, they haven't.
No, according to them, no, they're taking time. Now from today, it is barred by limitation that recovery.
No, in fact, my lord, statement, the skeleton of the statement of objections is ready. I will file it and make my submissions, my lord. Just 2 weeks time.
Fine. If it is ready, we'll take it up next week.
2 weeks, my lord, because there are the calculations has to be gone
My
through
lords,
it
may I
because
request costs to be imposed because this is an undertaking he gave sometime in July 2023.
I will file it, my lord, and make my submissions, my
And
lord.
this
If
is
there,
for the
if there
first
are
time
any
he's
liabilities
raising
to be
this
paid, I will instruct my
objection.
client to make the payments, my lord. It is not that,
Ultimately, your client is liable to pay. It's only
that's what, my lord.
What you're buying is time.
I'm not seeking for larger time, my lord.
Right from 23 Jan.
Correct, my lord. Now it is ready, my lord, so that I will file it and make my submissions. That's all.
Finally, same, this also on the 19th.
Very well.
This is matter on 19th. By the time the objections have to be filed, or else this court will consider that there are no objections and whatever is the application that will be allowed.
Please.
serial number 40,
This had come up last week, my lords. A memo of calculation has already been furnished.
Where is this council?
I have instructions that if a reconciliation meeting is conducted in this, Mullah, may be able to close this. I've gotten,
The same submission he made on the last.
no, please, on the
Pick a
last,
date and time, we're willing to sit down for a
we're
reconciliation.
also willing, a date may be fixed, but we're willing to sit down and close this out. I am not,
When is the date?
Tomorrow, my lords.
Tomorrow?
tomorrow may be a little tough only because, my lord, the officers of the company are in Delhi. I mean, sometime next week, I'm asking for a date we fix next week. It's not a laughing matter.
Yes,
Monday, my lords.
on Monday.
I will call for the, only indulgence to ask if in case they not make it on Monday, they'll make it next week.
We'll do it. We'll
Please.
pass out this matter, find out.
Please,
and
I'm
tell
grateful.
When are they coming?
Please.
But it shouldn't be after next Wednesday.
No, it will not be.
Before Wednesday
Please.
next week. Find out.
It may be passed over, please.
Yes.
41.
I'm in 41 as well, my lords. In this matter, apparently, my lords, outstanding, the principal amount is about 4 lakhs, my lords. I was told previously, before this matter came up, that the security deposit, which is not refunded, may be about the same amount. I'm still waiting for instructions on that. I may get some time for that as well, my lords.
Next
Pass
week,
over
my lord.
this also.
Very,
Plus,
The same day.
very well, very well.
please,
We'll pass over now.
Please.
And once you come up with
Please.
your instructions with
Please.
regard than the other matter,
please.
both we'll have on the same day.
I'm grateful.
Serial number 42.
My lords, 42 had also come up last week and we'd given them a memo.
Steps to be taken in respect of respondents. And 42.
42. Of service filed by all to R3 left.
The official liquidator shall take steps for service of notice on R1 to R3. This is matter on 4th of March. Next 43.
Serial number 43.
For the respondent.
What about
also,
43?
Pray for a short accommodation to file my objections, and if there is any reasonable amount, parties agreeable to look into it, because they are.
Pertains to what?
My lord, this is an application under 446. These are in the nature of original suits filed by the official liquidator seeking to recover monies from third-party debtors of the company who hadn't paid their dues prior to winding up, my lord. Respondent is one such person, ma'am.
What is your submission?
My lord, I am waiting for instructions. We have sent our objection statement for signatures.
What is the amount?
18 lakhs 94,000.
Because 8 lakhs is what the interest itself is coming up to 10 lakhs, my lord. 8 lakhs is the principal. Is what, so if there's something behind there, on the respondents are also going to shut down, my lord. They're not in a position of functioning. So if they give us a reasonable amount, maybe we can pay that and close it.
They'll let them, we have told the amount, my lord. If they want
18
some
lakhs.
reduction, give.
Then negotiate with them.
I'll ask them to speak, my lord.
When, where, how?
I'll have to speak to them because they're going to shut down, my lord. They're
But
not able to operate.
If I may invite you,
Official liquidator.
if I may invite your attention to order dated 21/2/24, my lord. 1 year they have been making the same submission. No effort
I
is done.
entered appearance
On
on that date, my lord.
21/2/24.
Not for your entering appearance. What is the submission that is made earlier? No, please get instructions from your client. When is
Yes,
he going
I
to-
did try to contact them, my lord. In fact, it's my colleague contacted them. He told that he'll need a little bit of time, a week or two, and then I'll.
What time? As it's a matter of course that he'll get time, ma.
May I make one other submission, my lord? He is submitting that the principal amount is 8 lakhs they're ready to pay. Let them deposit that principal amount in bona fides, my lord. We'll consider the interest part for allocation.
I'll give that proposal, my
Let
lord.
that
I'll
happen
propose
next
that.
week, my lord.
Then consider respondent submits that. The principal amount is 8 lakhs. Now. with
8 lakh
interest,
51,000
8,51,000.
076.
076. And now along with interest, there, it is calculated at 18 lakhs and odd. It is submitted by the land council for the respondent. In fact, the client is ready to pay the principal amount.
No, a reasonable amount. No, my lord, that's not my submission, my
It
lord.
cannot be a
That is not
reasonable
my
amount
submission.
which is less than
That
principal
is not my
amount, my
submission
lord.
at all, not the
Then
principal,
I-
because they're not in a position, they're going to wind up this company also, my
Yeah,
lord.
we can't help it. Then list this matter on next Thursday by the time. Then council shall place before this court appropriate instructions, the submissions, or else the court will pass appropriate orders.
Please.
My lord, with respect to
40.
objections, it may be noted as last chance, my lord. It is over a year time.
Yes,
Serial number 44.
yes, 44.
In serial number 44, I appear for the applicant's counsel. I'm sorry, I'm a bit unwell, therefore I'm just appearing on VC. What has happened is that we had made an application to the court asking that the OL be directed to put us in possession because property should have come to us, which was given on rent, my lord, to the company prior to the liquidation, prior to the institution of the winding up proceedings. During the course of these proceedings, this honorable court was pleased to appoint a commissioner. There were 2 schedule items. Apparently, in the first order, inadvertently, one item was left out, so there was a second order passed. After the commissioner appointment and visited and inspected the place, my lord, the occupant has surrendered possession, we have then taken possession. So to the extent of possession, the prayer, your court may record, I'll give the court the dates also, if necessary, I can file a memo, that insofar as possession. What would remain is adjudication qua the mean profits that we have sought from the official liquidator. That I will just make my submissions on the next day. Pleadings are completed. The court can give me some indulgence as far as that is concerned.
May I make my submission, my lord? With respect, this there is a question of maintainability itself on this matter, my lord. The alleged lease deed which they are relying upon, my lord, predates the presentation of winding up petition. The lease deed is not registered, not stamped. The lease expires prior to winding up order has been.
For how many years?
It appears to be for 3 years, my lord. It started in 2011 and it ended in 2014. The winding up order has been passed in 2017. There is no claim that can lie against the official liquidator in connection with those flats, my lord. If I may say so, this is a very cleverly drafted application to seek eviction of people who are highly placed, but the applicant is unable to evict under normal process. This shouldn't come to company court at all, my lord. Even then, my lord, the company court showed indulgence to figure out who is in possession of the property, my lord. An independent court commissioner was appointed, and as rightly pointed out by senior counsel, he has reported that the kin of former management resides. There is no leasehold right I am claiming as official liquidator. There is no ownership that I am claiming as official liquidator. They cannot make a claim against me in the form of CA. Even assuming they have a claim against the company for any mean profits, my lord, that claim has to be filed in the form of Form 66 with the official liquidator. That may be allowed, partially allowed, or rejected, my lord. If that is unsatisfactory to them, my lord, they have an appeal mechanism under Rule 164. So this CA in any event, my lord, looked at from all facets as well, is not maintainable. If they file a claim, if it is rejected, if they're aggrieved by the reasoning for that rejection, Rule 164 application has to be filed. In any event, this CA, in the form and manner that it is presented now, cannot continue, my lord. It has been already pending for quite some time.
Now, I don't need my learned friend's certificate on how the application is presented, but let me tell the court the facts of the matter. And my learned friend says that what we have done is clever and convenient. He conveniently ignores certain rules that he is bound by. Rule 535 of the company code's rules requires that if he, as the liquidator, official liquidator, upon the company going into liquidation, ultimately this, a lease is entered into, he is right in saying it was not a registered lease. But the point is it still, I'm sorry. I'm sorry. Still continues as a month-to-month tenancy. Now the point is that when there is any form of lease or tenancy, all of that, he steps into the shoes.
We heard this matter when you.
I'm grateful. I'm sorry. I apologize.
This matter on 20th of March. With the request of non-counsel applicant. Yes, 45.
Great.
45.
My lord, serial number 45, I appear for the respondents. My lord, in this matter, pleadings are complete. Objections, rejoinder are all filed. Matter may have to be referred, my lord, to the registrar for recording of evidence.
It may be, my lord.
My lord, only one submission on that. In similar matters, the OL has made a statement that they will not press the prayers against the directors. In this application as well, company, my lord, is first respondent. Directors are arrayed as respondents number 2 and 3. Same statement, my lord, may be recorded by the OL in this matter as well.
Yes.
That they will not press the prayers against the directors. Matter may then be referred to the registrar.
It stands on a different footing, my lord. It is let that facts be.
That a specific date to be given for the evidence to be let in before the.
Generally, registrar fixes his own dates, my lord.
He will.
A first date is generally given for him to start, and thereafter he manages.
That's what I'm saying.
First date may be given.
It is submitted by both the parties that the entire pleadings were completed. For the evidence party shall appear before the CPC on which date?
My lord, subsequent Monday after next, my lord.
Then that is 10th February,
Please, my lord.
on 10th February. Yeah.
Grateful.
Serial number 46.
There's appearing for the respondent in this matter.
My lord, this is also recovery of arrears of rent, but this is a tenant who has vacated. On the last occasion, we seem to have sought some time to file a rejoinder, but that may not be required. We can proceed basis the pleadings already on record.
My lord, I'm kindly seeking 2 weeks of time in this matter because the senior is, this due to some personal emergency, senior is not available in this matter, my lords.
My lords, it's a small amount of 4 lakhs and not, it may be had next week along with the other matters.
6. This is matter on 6 at the request of then counsel the respondent. Yes,
Serial
47.
number 47.
Lord, I appear for the applicant in this case, my lord. The matter was listed 2 days back, my lord. A request was made to the official liquidator to ascertain, my lord, the amount that is available, my lord, with the official
Yes.
liquidator for distribution.
My lord, the ambit of this application, my lord, I have no objection with the application. The scope of the application is that we call for claims from creditors to.
He has also no objection for that.
Please, my lord.
Only on the last occasion, what he asked was, what is the amount that is left as of now?
My lord, we don't have a running account on a everyday basis, my lord.
You were there, you said that can be.
My
extra time.
colleague was there, my lord. He's unwell today.
How it is, that is how it is.
Please, my
adjourned.
lord.
Otherwise, he has no objection for the, what is it, 5 rule number?
It is his application, my lord.
He said.
178.
When you said.
Please.
That if that 5-6, what is it?
178, my lord.
178, if the same as far as that is concerned, he said it's fine, but only the amount what is left with is what they wanted to know. The colleague said you will lesser time.
We can ask if it is not. We can,
So,
please.
because so that they'll have a clarity on how it is going on.
My claim is about
Can I-
27 lakhs,
Can I
my
make
lord.
a submission, my lord? If they ask us later after the matter also, we'll give them that information. It is just that we don't have it on hand.
Pass over. This way.
Serial number 48. Abhinavar.
Respondents.
Ganesh Bhatt.
Yes.
My lord, I am appearing for the petitioner, my lord. May I request for passover, my lord, in the matter?
Pass over.
Serial number
49.
49.
Please.
Serial number 49. Deepak Rajesh.
Respondent, there's an application made under 434(1)(c) seeking transfer. I filed detailed objections, but my lord, as per the rules, my lord, it is possible to transfer it. Only request, my lord, is kindly allow the application and direct this to be transferred to NCLT, but leaving all the questions that I have raised open to be considered by.
To be by that it goes without saying.
Lord,
be open
there's
for you to
some issues,
educate
my lord, which may arise. Anyway, my lord, they have made an application now for transfer. Therefore, it could be sent there.
Please come. Where is that application?
CA
374.
374 of 2024.
CH 74 of 2024. It's fine. What is that application seeking under 433?
No, ಗೊತ್ತಾಯ್ತು. ಸುತ್ತಿಲ್ಲ application. May I pass on?
We'll just. A number 374 of 2024 is filed. Seeking to transfer this petition, this application, this petition to the NCLT, Bangalore. It is stated that
Only para 16 and 17 possibly, my lord, the reasons. Otherwise, it's all history of what the litigation is. Page 8.
stated that the National Company Law Tribunal is now fully functional. And if the above case is transferred, the resolution professional can be appointed to resolve the matter under the insolvency and bankruptcy code. The respondents have filed their objections. And what are your objections?
Lord, it's, this application is filed after 8 years of,
Stating that the application is filed belatedly,
And-
only to drag on the proceedings.
and I've also said, my lord, there are jurisdictional issues which arise, which I will raise, my lord, before the,
There are jurisdictional issues and the matter cannot be transferred to the NCLT. Considering the nature of dispute that's pending before this court, where the National Company Law Tribunal has jurisdiction to deal with the same. In that view of the matter, this court finds force in the submission of the then counts for the petitioner accordingly. CA 374 of 2024 is allowed, and the company petition is transferred to NCLT Bangalore. And it is needless to mention that it is open to the all parties to raise their respective contentions on jurisdiction and all other aspects.
Read.
50.
Why you again arguments, sir? Who is supposed? Feels like the brain is not working. Yes.
My lord, these two applications, my lord. One is under 454, under 543, my lord. Other side, my lord, if there my lord, respondent, my lord.
I'm sorry, beg your pardon, my lord. Sorry, my lord. The counsel, Mr. Gopal Swami, my lord, has some denture issues. Denture broken down, my lord. Kindly put it off by a week, my lord, a week after next. Otherwise, I will land
Any
it.
urgency for you?
What?
Any
There is-
urgency for you?
There is no urgency, my lord.
The delete from the caption, why this is posted for arguments like, when was the order? The previous, there is no previous order.
Then everything is completed. My lord, evidence,
This case, that is some other case.
evidence and everything is completed, my lord. It is posted for argument. It has come up for twice, my lord, then subsequent.
Is submitted that the counsel for the respondent has some personal inconvenience. This is matters on 13th of March.
Much obliged.
Understood. Yes, next.
Cell number 51, 51 urgent. 52. Cell
My
number
lords,
52.
52, there are applications for misfeasance and non-filing of affairs which have to be heard. One of the ex-directors have filed recall application seeking to recall the stage closing their evidence. It's for their arguments today. This is CA 416 and 415 of 2024.
Appearing for the respond number 3 and 4 and the applicants in this application for recall, my lords. The arguing counsel senior is having some inconvenience, maybe taken up next week, my lords.
The request of the counsel for the applicant. This is matters on 20th of March.
20. Cell
Great.
number 53, urgent. Cell number 53, urgent 54. Ms. Chaldev, we are for petitioner.
Petitioner, my lord.
My lord, I am appearing for respondent.
Ready.
It's a
No, the
loan.
final hearing, you want to appear online.
Yes, ma'am. Ma'am, I will come physically, ma'am, may be posted in the next week, my lord.
Final
Oh,
hearing.
it's
already been.
It may be posted on 14th, my lord, the 13th, my lord, 13th.
13th?
13th, it may be posted. In the next week, I am some inconvenience. I will come and personally appear.
Can I request an earlier date, my lord? It's 2014-15 matter.
15th
my lord.
February, at the request of counsel for the respondent. Yes,
13th, my lord.
yes.
Okay.
Number 2, 13th February.
Yes.
Number 2, Pattern matter cell number 1,
Kindly pass over, my lord. Please held up.
Kevin Nasiman.
Next.
Cell number 2, Kumar Kayar for petitioner,
Matter
Kayar
petitioner.
Ramesh for
This is
respondent.
the suit filed by the first respondent. I filed an application before the trial court, permission to file a wakala, no, permission to file a written statement. Along with application, I filed a written statement. That application has delayed, only 3 days delay in filing the application. The fact of the case is that, Your Lordship, the suit is for the performance.
Where is the counsel for the respondent?
Last 2 occasions are they not appeared.
What I'm looking at, it doesn't say so. There is no representation.
Yes, yes.
Yes, argue.
The suit is for effective performance filed by the first respondent. And the agreement dated 3/1/1992.
Hmm.
At the time of filing of the suit, they have made a parties, the vendors of the parties different 1 to 4. Subsequently, these petitions are implemented in the 2013. They have filed an application, Order 1 Rule 10, on 8/10/2013. That application is allowed in the year 2015. Subsequently, the suit summons was issued to the petitioner. Even the RPD is not served. There was subsequently has taken a paper publication. After it came to know that we filed an application on 9 Rule 7 on 1/8/2017.
To the impugned order.
The impugned order. Registry 7/10/2017. The instant IA filed with the opponent defendant number 6 seeking a permission to file written statement by condoning the delay. In the affidavit, it is stated that the defendant number 6 is that he knows the facts of the case and the case was posted for filing of the written statement and he was unwell. He could not file the same. That the written statement of each side was taken as not filed. He further stated.
When were you impleaded?
2000. And 8/10/2013, he filed an applications for impleading me. I am the purchaser.
8/10/2013 is the
The 13.
IA. When was that IA ordered?
That IA was allowed on this not, but I filed an application, alternate rule 7, 1/8/2017.
Stating what?
The place of the petition is to take expert.
Affidavit. Neither this order do contain any reasons, nor where is that affidavit?
Affidavit in support of that application. IE.
Where is that?
Annexure C is an IA. The affidavit, page number 25. I am the defendant in the above case. I know the facts of the case. The above case was posted to file written
Something
statement.
wrong with the pagination. 35 is the docket order.
Page number 25. 25. Annexure C. Along with an affidavit. IA filed along with an affidavit under section 151.
What did you say?
I submit, I am the defendant in the above case. I know the facts of the case. I know the above case was posted to file written statement on my side.
The docket proceedings, let us see, when is the matter posted? You filed the docket proceedings, where are they?
Page number 43.
So on
18.
4/9/2017,
Yes,
heard advocate for defendant 6,
yes,
praised time for written statement as a last chance with cost of rupees 300,
Yes, yes.
call on 12/9/2017.
yes. Next,
After that, heard advocate for defendant 6, further time
yes, I supported for 14,
on 12/9/2017.
17,
Court had taken as no.
not filed list.
As
And-
nil. Hmm.
And posted on 14/9/2017, the defendant present file an IA under section 150.
Before that,
12/7 it is not filed. 12/9/2017,
defendant number 6 is permitted to come on record
yes,
and contest the suit.
Yes.
This is allowed with cause. When is this order?
and 1/8/2017. Order IA filed by the defendant number 6, order 9 rule 7 CPC, the
This is on
instant
16.
1/8/2017,
1/8,
page number 45.
2007.
Page number 45.
Please come. Agreed with the orders passed. On an application under section 151 CPC, permitting the petitioner, defendant number 6,
Yes,
to file the return statement by condoning the delay. The defendant is before this court. The respondent herein has filed a suit for specific performance of the agreement of sale. And by order dated 1/8/2017, the defendant was permitted to come on an order that the IA filed by the defendant to set aside the ex parte order is allowed, and he was permitted to contest the suit. On 29/8/2017, on the request of learned counsel appearing for the defendant number 6, time is granted till 4/9/2017 to file the written statement. On 4/9/2017, again, time was sought and the same is granted on cost of rupees 300. And on 12/9/2017, when the written statement is not filed, and the written statement, and the court has taken that as not filed and posted the matter for arguments. Immediately on 14/9/2017, he has filed an IA seeking to file the written statement.
along with statement.
That
Along with statement to file.
along with the written
Yes.
statement that came to be dismissed by order impugned, whereby the court has observed that the perusal of the order sheet reveals that in spite of availing sufficient opportunities, the defendant number 6 has not filed the written statement. As this is the case of the year 2006, the grounds made out by the defendant number 6 in the IA are neither sufficient nor satisfactory, and accordingly dismiss the IA. Learned counsel appearing for the petitioner, defendant number 6 submits that, in fact, though suit is of the year 2006 is completed at a later point of time. And when he came to know about an ex parte order that's passed, he has filed an application on 8/1/2017. That order was set aside and he was permitted to contest the matter. Except on 2 occasions, he has never sought for time. And the court has taken the written statement as not filed and proceeded with the argument. He submits that if the said order is not set aside and is not permitted to file the written statement, he will be put to a lot of hardship. Next para. So notice is served on the respondents. Where is that? The R3 to 6 notice is served. R2 to R6 notice is served, no representation. For R1, Wakalat is filed. But there is no representation on behalf of the respondent from the last two occasions. Hence, the matter is posted under the caption part heard. Today also, there is no representation. Next, for having heard the counsel for the petitioner, peruse the entire material on record. As per the docket proceedings reveals that the petitioner has asked for adjournment on two occasions for filing the written statement. On one occasion, the court has granted the permission on by imposing costs of rupees 300. And again, then when the next time, when the time was asked, the court had taken the written statement as not filed and posted the matter for argument. Considering the fact that the court observes that it's a suit of 2006. Admittedly, petitioner came on record in the year 2017 and 2017. Considering all these facts and the fact that if the permission is not granted to file the written statement, it was cause a lot of prejudice to the defendant, and further, it would further in the substantial interest of the parties and to put a quietus to the litigation, this court deems it appropriate to pass a following order. Accordingly, the order dated so-and-so is set aside, and the IF filed by the petitioner is allowed on the on the condition that he shall pay costs of rupees 1,000 to the plaintiff. Accordingly allowed.
Statement is already filed.
Huh?
Statement is filed before.
Statement is already filed. No, it is.
Yes, please.
Cell number 3. Jane Puttegowda for petitioner. Harish HV.
Presenting for R1, my lord. Kindly pass over the matter, my lord.
Pass first.
Cell number 4. MS Nagaraj for petitioner.
Yes. My lord, the petitioner is a judgment debtor in execution proceedings, my lord, being aggrieved by the order passed by the execution court by allowing the application under order 21 rule 54 filed by the decree holder. We are before the court, my lord. By grievance, my lord, she is an employee. Some substantial amount has been recovered, my lord. See, after execution, the substantial amount has been recovered. They filed an execution amount is recovered of 2,71,000, out of which, my lord, 50% of amount has been recovered through the salary. After this, she retired a moment, my lord. They filed an application for seeking in a provisionary order. The application is filed, my lord, restraining the defendant from the judgment debtor from alienating or encumbering the property. That is house property where she is residing. That property they are seeking a provisionary order under 24 rule 54. My lord, under order 22 rule 54, my lord, a notice is to be, if the property wants, they are sought for an attachment, a notice has to be issued to the other side, my lord. She calling upon show cause notice like 54 1A. Notice, there is no notice has been issued. My lord, she has not denied to pay. And my lord, even trial court is observed, my lord, they have not filed a memo calculation. What is the amount she due?
Very simple note.
That is impig note, my lord, at ink page number. The typed copy have also produced, my lord. Ink page 44, my lord, please.
Yes.
Shall I read, my lord, para 10 of the order?
Yes.
According to the DHR, admittedly DHR is a retired teacher. There was no means to available her DHR to recover the decree amount. Recently, he came to know that JDR has an immovable property. Now she is intent to dispose of the same in order to defraud the DHR. Hence, it is necessary to pass a provisionary order, but JDR has contended that the present application itself not maintainable as no attachment of or provisionary relief as claimed in the said application. It is seen in that IA number 29 filed under order 21 rule 54 ICPC, which deals with the attachment of immovable property. When the property is an immovable property, attachment shall be made by prohibiting the GDR from transferring or creating any charge over the property. The attachment shall be enforced by passing provisionary order in the said application. DHR is asking JDR not to create any charge over the property or alienate the same, which is nothing but prohibitory order, though specific word is not mentioned. As rightly pointed out by the DHR, he has no other means to recover the money from the JDR other than by way of an attachment. Learned advocate for JDR in the course of the argument submitted that JDR has received some pensionary benefits and he would take steps to settle the claim provided these file a memo of calculation. Keeping open, they said both parties may be direct to file a memo of calculation. As record this present application, DHR apprehension is well founded, taking into the consideration that original case was in the year of 2001, which was disposed in 2007, and the present execution petition is pending since 2007. In the interest of equity and justice, order enabled to JDR is to recover the decretal amount, keeping in view of the Motor Vehicles Act beneficial legislation. I am of the opinion that application deserves to be allowed. But memo of calculation, they are not filed.
It is. No, that will be decided. That will be decided. It's only like you are only prohibited from alienating the property.
But Lord, the attachment has been made. Order, your lordship, has to be appraisal.
Rule 50.
Subject the court attachment. My lord, what amount they are entitled? Some amount has been recovered, my lord. More than 50% of the claim they are made from her salary. Immediately retirement, they filed an application. In case of 21 Rule 54, my lord, a notice has required to be issued to the JDR.
Before the
Maybe, my lord, that's my lord.
what is the
Unless they filed a memo of calculation, what is the amount recovered, what is due?
If the property is immovable property, read it. The attachment shall be made by an order prohibiting the judgment debtor from transferring or charging the property in any way, and all persons from taking any benefit from such transfer or change. The order shall also require the judgment debtor to attend court on a specified date to take notice of the date to be fixed for setting the terms of the proclamation of sale. The order shall be proclaimed. So what is wrong with this?
It's a proclamation. If it is say attachment, court is passing not only provisional order, attachment has also been made. That's what. There is a one proposal as second, they are not filed a memo of calculation. Even the court is also observed that memo of calculation they are directed. They are not produced them. File the memo of calculation. What amount is recovered? What is remains to be balanced? JDA, my lord,
exercise will be done by the court. No,
I have categorically, he himself is before the court stating that memo of calculation is filed. We are going to settle the matter. What is the necessary for passing in an attachment order, my lord?
In the meantime, if you sell the property,
my lord,
you settle the
that's
dispute.
They have to file a memo of calculation, my lord. What amount recovered?
Well, then that attachment will be raised the moment you settle the whatever is the due.
Let them file a memo of calculation as directed by the trial court, my lord. They are not filed it.
We'll give that further direction. Let it be there.
Maybe they settle the, my lord. Attachment cannot be made unless the notice.
It can be made. It can be made under order 21 Rule 54.
That's what, my lord. They say attachment, my lord. So for attachment,
so you have come before this court. Tell the court what is the amount due according to you, and how are you going to pay it? No, don't go on the technicalities. The fact remains is that
that's what they're making. Frankly, they have made a submission before the court. Let them give the memo of calculation. What amount they're secured. She is a government employee, my lord. Amount has been deducted from her salary.
But whatever it is, whether it is substantial amount is deducted, whatever remains is remains. That we are that you are liable to pay.
That, my lord, yes, my submission, my lord, we are ready to settle the matter.
Who stopped
yes,
from settling?
That's what, my lord, this is the attachment has been made. Unless an opportunity has been given to her to know that what is the amount is due.
Even if you do it later part also, that attachment will be raised.
Observe that and remand the matter.
The agreed with the orders passed in I number 29 and 30 in execution number 184 of 2007 dated
1 minute. 6/9/2019.
6/9/2019, the judgment debtor is before this court. The decree holder had filed an IA. Had filed IA number 29 and 30.
That is amendment we are not calling. That is only measurement of property.
You are concerned with IA
29,
IA number 29. To restrain JDR from selling the immovable property or mortgaging the same to any bank in the interest of equity and justice. It is the case of the judgment debtor that after salary attachment, he has obtained part of the amount and still 2,50,000 is balance from JDR. He retired as teacher about 2 years back and never paid any amount. Recently, about 2 days back, DHR came to know about the immovable property standing in the name of JDR. And she is intending to sell the said property. And immediately has come up before the court. The JDR has filed his objections, stating that there is difference in the measurement shown in the application with that of the documents. Already a sum of rupees 1,24,317 has attached from the salary. And till date, DHR has not filed any memo of calculation. It is stated that the JDR does not have any movable property. The court by order impugned had allowed the said application. The court gives a finding that the DHR apprehension is well founded. Taking into consideration the original case was of the year 2001, which was disposed of in the year 2007. And the present execution petition is pending since 2007. And in the interest of justice and equity, in order to enable the DHR to recover the decretal amount, keeping in view that Motor Vehicle Act is a benevolent legislation, the application deserves to be allowed and accordingly allowed the petition. When counsel appearing for the petitioner, the decree holder submits that when there was no memo of calculation, when the substantial amount is recovered, the court ought not to have allowed the application, and without an opportunity as contemplated under Order 21 Rule 54 1A, the court ought not to have attached the property by allowing the application filed by the judgment decree holder. You appear?
I appear. Respond.
When counsel appearing for the respondent, decree holder submits that there is no illegality with the order, and as contemplated in Order 21 Rule 54, the court is competent to attach the property as the judgment debtor failed to pay the decretal amount. Next, by having got the counsels on either side, peruse the material on record. The court's power as far as Order 21 Rule 54 are concerned, and for attachment of the property, there cannot be any dispute. And there is no dispute about the fact that the amount, the judgment debtor is said to pay the amount to the decree holder. It is a case of the judgment debtor that the memo of calculation is not filed. What is the outstanding amount is not determined. And there was no opportunity given to the judgment debtor to settle the amount and to pay the amount. Even that argument of the land counsel, the petitioner has no legs to stand. Considering the respective submission of both the counsels, this court is passing the following order. This court do not find any reasons to interfere with the order impugned. However, if the petitioner, if the judgment debtor is ready to pay the decretal amount and settle the matter, it is open to him. And on such, if once it is settled, the attachment order would automatically get.
They are directed to file a memo of calculation. What is the amount?
If you want that will follow.
My lord, we are deposited, my lord, in terms of interim order 50,000.
How much?
50,000 before this honorable. It may be
The amount of
order to be
50,000.
transferred to
The amount of 50,000 which is deposited before
maybe-
this court shall be transferred to the executing court.
and same may be, my lord, permitted to withdraw it, no problem. But adjusting, my lord, they have to file a memo of calculation.
Respondent decree holder can withdraw the amount. Thereafter, the decree holder shall file a
Memo of
memo of
calculation.
calculation. And basing on that, if the judgment debtor pays the amount.
Allah,
appropriate
will
orders-
pursue it, my lord. What is the amount? Do you?
Appropriate orders will be
Yes,
passed by the,
please.
shall be passed by the court.
Can,
Dispose of. Yes, next.
My lord, one submission.
Bill number 5.
My lord, list to serial number 2. I am for the first respondent in this matter, my lord. My lord, the petition was allowed in the last, yesterday, my lord, I am waiting for last 4:30. The matter was not reached, then, my lord, the matter was today called out.
It is allowed on cause of control.
My lord, in the matter, my lord, the petitioner here in defendant number 6 before the trial court. They have appeared before the trial court in the year 2014, they expert. Then, my lord, they after lapse of 3 years.
You filed the application in the year 2013 and by way of a paper publication, you have taken notice. Then they filed an application under, but to set aside the ex parte order, that was passed in the year 2017. Only on one occasion.
Three
he
occasion,
sought-
my lord.
One occasion he sought, time was granted. On the second occasion, 300 rupees was the cost imposed. On the third, they have taken the written statement as well.
Well,
And
the-
immediate next day, they find the written statement.
My lord, in the
Along with
application,
an
in
application.
the application, my lord, they have not stated anything about the, my lord, why there is a delay in the filing the application.
No, let it, that will be,
Right.
then if that, that respondent one no apparent, no? Then say the counsel appearing for the respondent as opposed to the petition. And he submits that the court has rightly considered as there are no reasons to, as a defendant intentionally had not filed the written statement and was dragging on the proceedings. It is submitted that in the IEF filed in support of the application, it is not even stated why the written statement has not been filed and what are the reasons for such delay.
Please, oblige.
Yes.
Sorry for. Please.
Number 5, Penmukappa for petitioner, Mohammed Nasiruddin for respondent, Kavita.
Was he there on the last occasion?
They were absent.
Last occasion, also. Yes.
Petitioner is the defendant before the trial court, madam. The application which was been filed by the defendant.
Tell this lady, in every matter I said, no representation for the respondent. Well, who is with PS or something? He came yesterday. Yes. Yes.
Lord, the petitioner is the defendant before the trial court, madam. The defendant had filed an application under section 10 of the CPC, seeking to stay the proceedings which has been initiated by the plaintiff. On the reason that, on the ground that earlier to this suit, the defendant has already filed a suit for declaration. Lord, my suit,
What is your suit?
suit for declaration, my lord.
Which year is the suit? OS
2011, my lord. 26750 of 2011.
26?
750 of 2011.
Suit for declaration.
Declaration. Wide Annexure G, my lord.
And what is the present suit?
This suit is for the declaration which has been filed by the defendant in my suit. OS number 193 of 2014, which is the Annexure B,
193 of
2014,
seeking declaration with respect to the very same property.
very same property,
Then?
wide Annexure B.
Hmm.
Therefore, we filed an application in section 10 of the CPC. Earlier to this suit, my lord,
Which year?
the application was been filed in the year 2019, my lord.
Hmm.
The application was been dismissed. Therefore, we are before this honorable court.
On what ground?
On the ground that the subject matter is different.
You're saying same.
The impugned order came to be passed stating the subject matter is
No,
different.
now let's see the plaintiff.
Please.
OS number 26750. Page
And
number.
Page number 53, my lord. My lord, plaintiff is the defendant herein.
Let's see what is the. The relief. Declaring that the plaintiff is not a tenant.
Under the 11th
defendant.
And prayer B is
Declaring
declared
that the sale deed dated executed by defendant number 1 to 10.
in favor of
11
11.
defendants which are registered as documents so and so. As not binding on the plaintiff.
Please, my lord.
You sought a declaration that you are not a tenant.
Please, my lord. That was a negative relief. But insofar as the prayer B is concerned, my lord, I sought a declaration declaring that the sale deed
Sale
which
deed is not binding.
binding on. Now the defendant number 11
Injunction restraining the defendant.
from alienating the property and
Defendant is the plaintiff in the other suit.
defendant number 11, my lord.
No, please come to that suit. Which
Next.
page?
Annexure B, my lord.
Page number
Page number 16.
60.
16, my lord. 16.
Come to the prayer. For a declaration,
page
the
number 20,
plaintiff is
declaration.
absolute owner of the scheduled property and recovery of portion of the scheduled premises. Vacate and deliver vacant portion of the scheduled, hold an inquiry.
Regard to the means profit. I request your lordship to see the paragraph number 3 of the plaint.
Your suit do not contain what is a suit scheduled property, nothing.
Lord, I
And
request,
here he is seeking I say comprehensive suit for declaration.
please,
That
ma'am.
he is the owner of the property. Why should that be state?
Lord, schedule B property in my plaint, my
You are
lord, page number 16.
contesting that suit, contest that suit.
Lord, my suit is the earlier suit, my lord. The
Now,
sale
might
deed which has
be,
been,
what are the reliefs you sought? You
The-
say there's some, you don't seek any declaration that you are the owner of the property.
I-
You don't seek a declaration or that you are a tenant. Instead, you seek a declaration that you are not a tenant. Sale deed is not binding on you.
insofar as the plaint awareness is concerned, my lord, I state that I'm the owner of the suit schedule property. And I consequently, I state that the sale deed which has been relied upon by the plaintiff in this suit is not binding on me.
When somebody else is having a sale deed, unless and until the court declares that you are the owner of the property, how come you say that?
Issues
you're-
involved is, my lord, I need to prove my ownership over the same in the first suit which has been filed by me. Apart from that, my lord, earlier to this suit which has been filed by the plaintiff herein, I request your lordship to see that he had also filed a HRC petition, my lord, which has been stayed. Word annexure F, my lord. The plaintiff herein in this suit had filed a HRC petition seeking for eviction against the defendant herein, my lord. I request your lordship to see page number 43, my lord.
The manner in which you have framed your suit, and this suit cannot be stalled under section 10.
I request you just page number 52, my lord.
Yes.
I filed an application under section 43 of the HRC Act, seeking for the stay of the said HRC proceedings, stating that already the declaration suit which has been filed by the defendant herein is for pending consideration. The application was been allowed in the HRC petition. I request your lordship to see the impugned order which has been passed in the HRC petition at page number 52, man. May I, ma'am? Interlocutory application filed by the respondent under section 43 of the Karnataka Rent Act 1999 is hereby allowed. Consequently, further proceedings in the present case are hereby stopped, and the parties are hereby directed to approach the competent court of civil jurisdiction for declaration of the rights or till disposal of 2650 of 2011 pending before the City Civil Court, Bangalore. The proceedings which has been initiated by the plaintiff herein was already been stayed. Subsequently, the suit which has been filed by me, the evidence has been commenced. Then, my lord, he files this suit.
Can you stop him from declaring himself as the owner of the property? You are not seeking any declaration in respect of that property.
Same property, my lord.
Where did you seek the relief of declaration?
My lord, in so awareness are concerned, I state that I am the owner of the property.
How can his suit be stayed when he is seeking the relief of declaration? When that is not the prayer in your case, you simply say some sale deed is not binding on you.
The sale deed which has been executed in favor of the plaintiff herein, based on the same sale deed, the plaintiff herein is leading his case, my lord. I just request your lordship to see the plaint which has been filed by him. At paragraph number 3, my lord.
No, the relief
Page
that
number 16.
you're seeking at A, that's for the court to decide whether you're entitled for such a negative relief. What you're seeking is
The
one.
suit has been dismissed, my lord. RFA has been filed and it is for the pending consideration. I request your lordship to see the paragraph number 3, my lord. My submission is this, my lord. If the sale deed has been set aside, based on the same sale deed, the plaintiff herein is claiming his ownership of the property, there will be a contrary views. That is the reason I filed a section 10 application. I just request your lordship to see the paragraph number 3 at page number 16.
No, why it is not binding on you? That I'm not able to understand till now.
But in the
You should
awareness,
say That I am the owner of the property.
I have stated, ma'am.
Purchased the property by way of so and so, so and so.
Please, my lord.
The sale, where did you say? Let's look at your plaintiff.
In the averments, my lord.
Let's see at the plaintiff. Plaintiff is the absolute owner in possession and enjoyment of the property. How?
Request your lordship to see the paragraph number 4 wherein paragraph number 4 of the plaint at page number 55, my lord. He submitted that land in survey number 56/3 was purchased by the plaintiff's father and a registered sale deed dated 28/12/1971, which is registered as document number so and so from one Sheikh Baba, and apart from the said land, he had also purchased the land in survey number 55/19, measuring 38 guntas, and he has permitted the plaintiff's husband to put up construction on the scheduled property, and accordingly had put up constructions on the scheduled property, and he was in possession of the scheduled property to the knowledge of the entire world, including the defendants herein. It is submitted that, as stated above, building was renovated and now the RCC building is in existence, for which the plaintiff has incurred an expenditure of rupees 5 to 6 lakhs in the year 1992 itself. And the constructions taken by the plaintiff's husband was not obstructed by any person, including the defendants herein. And as such, the plaintiff is enjoying the scheduled property for the last 39 years. Thus, the plaintiff has acquired right, title, and interest in respect of the scheduled property. It is submitted that father of the plaintiff had purchased the scheduled property in the year 1971.
Who has executed the sale deed dated 34/20/2005?
My lord, defend number 1 to 10 in my suit, as his father had executed a sale deed in the year 1971. Now his children, my lord, his children have executed a sale deed in favor of the plaintiff herein. Therefore, I sought a relief of declaration declaring that said sale deed is not binding on me. Further, my lord, at paragraph number 7, it is submitted that based on the said sale deed dated 34/2005, the 11th defendant has filed HRC number stating the plaintiff is a tenant in respect of the building in existence on the scheduled property, giving the schedule. The said petition as mentioned in the schedule given here under. Herein after
Dismissed.
Lord, suit was been dismissed in the year 2013. Immediately I filed an RFA and it is for pending consideration. RFA number 115523, my lord. Same relief, my lord. My submission is this: I have challenged the sale deeds, which has been executed by my vendor's legal lawyers. So if that goes, my lord, the plaintiff is not the owner of the suit.
All the more reason that no, your suit itself is dismissed. Let his suit go on. Please.
Lord, my submission is that RFA is nothing but the continuation of the suit.
The agreed with the order. Where is that order?
And even, my lord, in the HRC proceedings which has been initiated by him,
Stayed, might have been stayed.
but there is categorical finding stating that he is not the owner of the property. There is a serious doubt about that. Therefore, the HRC petition.
After lunch will pass off.
List number 2, serial number 20. I informed the other counsel.
Serial number
20, my lords.
Siddhappa PM.
Yes, my lords.
Kashinath JD.
I informed.
This is matter on 24th of March. Counsel the petition.
May I make a mention, my lord? I do apologize. Serial number 49. An application was filed yesterday. The matter was heard initially regarding transfer to NCLT, my lord. My due apologies. Only I wanted to apologize that I was not present.
Disallowed. Yes.
Not serial
But
number
only
11.
submission is if my presence may be noted.
Presence was not, your absence was not noted, please.
Okay.
Serial number 11, my lords, list 2. Lords had ordered and hand summons, my lords, last week. Last Friday, my lords. Lords, next week, my lords, any date, because I have received yesterday, my lords, the hand summons copy to give it to respondents.
Filing of memo.
Please.
Acknowledgement for having served hand summons.
Please.
What happened?
I have received it yesterday, my lords. I have sent it today to
Then
the
also the
trial
petitioner
court.
submits that he has received the hand summons today.
Yesterday,
And
ma'am.
yesterday, and he has sent the same. List is
Next
smarter.
week,
List is smarter after 2 weeks.
My lord, serial
Lord,
number
serial number
40.
10, my lord. Same
Rent
list. Serial
recovery
number 10.
matter where they undertook to appear for reconciliation before the OL. We've agreed to have the meeting through video conferencing. Any date?
We'll pass the order in the afternoon.
Please,
Serial number
pass
10, my lord.
Please.
10, my lord, in the same list, my lord. The lordship may give a week's time, I can will comply the condition.
In which case?
Second list, serial number 10, my lord.
10.
10.
My lord,
Finally,
serial number 31. is
finally,
to-
10 days time is granted to comply with the office objections. Yes,
But-
orders.
Serial number 31, my lord.
Lord, list number 1, my lord, serial number 57.
No adjourn. What is that? Yes, Mr. Counsel.
Passed over.
Lord, list number 1, my lord, serial number 47 is passed over. Could it be taken up next week, my lord?
No, it can't
Some
be.
personal inconvenience in the afternoon.
We'll pass off. Just what you want to know is about the amount that we will specify and
Yes,
we'll pass
yes.
an order. We'll pass an order. It can't be adjourned every time like this.
Very well, my lord. Madam, Passover matters ಯಾವಾಗ ಕರೀತೀರಾ? Court officer? Hello, court officer?
ಹೇಳಿ ಸರ್.
Passed over matters ಯಾವಾಗ ಕರೀತೀರಾ ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್?
ನೀವು 2:30ಗೆ ವೇಟ್ ಮಾಡಿ ಸರ್. I have to take the instruction from the court, then I have to call the list.
Okay, okay. Generally 2:30
I
ga?
am not having any instructions to.
Okay, okay. Sorry.
Kada memo book koda. List 2 and serial number 5. ಅದೇ ಡಿಕ್ಟೇಷನ್ ಇರೋದು.
Serial number 30, my lords. Seek adjournment, and my lords, the previous council has issued me NOC. His name may be there and my name may be.
List is over, I think. List is completed as of 30 is concerned. 30, what happened to 30?
Which one? This
Lease two, my lord.
What happened? Somebody made a mention in the morning, I think. List 230. What do you want?
Adjournment, my lords, and previous.
Why
council-
are you making mention now? Which you're not supposed to. It has to be, my adjournments are only at 10:30.
I had mentioned, my lords, it was instructed to inform the other side, my lords.
Yes. At the request, this matter on 17th.
Previous council, let me
March.
take. Previous council, my lords, he has given NOC.
All that you do, you file your, yes, next.
17.
Call the password. One.
Passover matters in list number 1, serial number 16.
I may be permitted.
Have you given him?
I'll give right now.
Rectification ಮಾಡಿದೆ. I'm ready to address my arguments in this.
You don't want to go through this?
No, I can address my arguments. It's basically, there was a typographical error on their part, which has
That
been
is
corrected.
rectified
That has been
now.
rectified.
Oh.
But the principal point that remains is whether stamp duty is payable on leasehold property, where basically there's a government agency called Karnataka KDB. KDB had given a lease come sale agreement. That lease terms have not been fulfilled. There was various challenges from
Lease
KDB.
is for how many years?
Leases for only for 10 years.
Then it's it has to be registered.
It has to be registered, but the challenge is there are some conditions under the lease saying that you have to fulfill some obligations of building and all
Whatever
this
it
thing.
is.
And
If
today,
anything above, any lease above 11 months is a compulsory registrable one.
not really, madam. Yes, that is correct as regards. We have registered the lease originally. That is not in dispute. Now, what has happened is there is a stay order against the property itself by KDB is not able to hand over peaceful possession to us. So that matter is before this court in another writ petition. So only after the disposal of that writ petition can we develop that property. So today it's only leasehold rights that I have. Even otherwise, this court has in various in the past, if there's transfer of leasehold rights under a scheme of amalgamation, there is no specific provision under the provisions of Karnataka Stamp Act levying stamp duty on a leasehold rights. So what the article provides for is Article 20 subclause 4, 3% on the market value of the transfer company located within the state of Karnataka. The Lordship has Article 20 subclause 4.
Article?
Article 20 subclause 4. It's another thing, the order of amalgamation is not required to be registered at all under Section 17 of the Registration Act. So if relating to an order made by the High Court or appropriate tribunal or appropriate authorities under the Companies Act in respect of amalgamation of companies, including subsidiary company amalgamating with the parent company. This is the case. 3% on the market value of the property of the transfer company located within the state of Karnataka and transferred to the transferee company, or an amount equal to 1% of the aggregate value of shares issued or allotted in exchange or otherwise, and in case of a subsidiary company, shares merged or cancelled with parent company, and in addition, the amount of consideration if any paid for such amalgamation, whichever is higher, subject to a maximum rupees 25 crores. Here, Lordship, there is no provision with, here it says, if it is a leasehold rights, what is the stamp duty payable? Now, the Article 5 of the Stamp Act provides for leasehold rights. If it is 11 months, what is the stamp duty payable? If it is 5 years, what is payable? And 11. Now, here's the case of a lease cum sale agreement where there's no time period prescribed. Ideally, I should have finished my term by now, which I've completed. The government should have allotted the land because of their incapability for various reasons.
What Article 5 says, let's see.
Sorry, So Article 53, my apologies.
Article?
53. By way of assignment and not by under lease, where the remaining period of lease does not exceed 30 years, the same duty as conveyance for the market equal to the amount of consideration. Here, there's no consideration assigned to the transfer of lease, hence you can't levy stamp duty under Article 53 also. Now, then going to the provision which relates to lease.
Where the remaining period of lease does not exceed 30 years, the same duty as conveyance for a market value equal to the amount of consideration.
Now here, there's no consideration attributable in a mass.
Duty as conveyance on the market value of the property. Next, B.
If it is exceeding 30 years. Here, there's no time period prescribed here. And that is not their contention also under the affidavit. Their contention is, since under Article 30, Your Lordship, Article 30.
Article?
30. Lease of immovable property, including an under lease or sublease, and any agreement to let or sublet whereby such sublease the rent is fixed or fine or premium or money advanced or security, where the lease purports to be for a term not exceeding 1 year, then it's 50 paisa for every 100 rupees or part thereof on the total amount or value of the average annual rent, premium, fine and money advance subject to a maximum of rupees 500. Where it exceeds 1 year, then it is 50 paisa for every 100 rupees or part thereof on the total amount of value or average annual rent, premium, fine or money advanced. Subclause 3, where the lease proposed to a term exceeding 1 year and not exceeding 10 years, it's 1 rupee for every 100 rupees. Then 4 is where the lease purports to be for term exceeding 10 years, it's 2 rupees for every 100 rupees of the average annual rent. Now here, what is the average? And then if this is the provision in which they have to go, then they have to determine what is the average annual rent. That is not the contention that they have taken also. They have
Article 53 clause 1 clearly it says, kindly see, Article 53 clause 1.
No, what they stated in their affidavit pleading is what they should look at.
53?
Clause 1. There it says, A number. Whether the remaining period of the lease does not exceed 30 years. Here is that The
The
same
same-
duty as conveys to the Art 20 class 1 of the market value equivalent to the amount of the consideration. So kindly go through the Article 20 class 4, my lord.
Clause 1.
Article 20 class 4. Class 4. 20 class 4. Class 4. Adralli ಒಂದು. In that amalgamation of the companies including a subsidiary amalgamating and with the parental company here 3%. Here we have initiated 2%. Earlier that valuation was done in the earlier year. That's why the 2% has been initiated here. On the market value of the property of the transferor company located within the state of Karnataka and transferred to the transferee company or an amount equivalent to the 1% of the aggregative value of the share issues are allotted in exchange of or otherwise in the case of the subsidiary company. Shares merged or cancelled with parent company and in addition to that amount of consideration, if any period of such amalgamation, whichever is higher. Here, we are taken to the valuation of the movable immovable property that also comes and on the share value also.
What is the value of the property?
Property value 70 crores. 70 crores 42 lakhs 39,701 rupees.
No, that's a wrong statement.
70 crores 42 lakhs 39,701 is the valuation report itself is there. And apart from there, we have taken the 2%. 1 crore 40 lakhs 84,800. That was the stamp duty as prescribed in the law. 20 class, Article 20 class 4 of the Stamp Act.
Your Lordship, under this memo that they filed, the value of property is stated to be 15 crores, not 70 crores.
So the value of the property, immovable property and movable property, both we have taken.
I'm not in country.
Take movable property.
Both are there. Movable, immovable, both we have to take. Immovable and movable, both we have taken.
The point of contention is only relating to the immovable property. I'm not even contending on the movable property or the value of the movable property. The value as per them in the affidavit is 15 crores as regards immovable property is concerned. Nowhere they refer to Article 53 or under which article they're charging. It's a random statement that they've made saying that we will charge stamp duty as if it is a conveyance without any reason or justification as to how they're making such a statement.
What is your submission with regard to this 53?
So, Your Lordship, my contention is that Article 53 does not apply in this case. It is not as a case of a transfer of lease, which even if you look at Article 53, it refers to a provision of the same duty as conveyance under Article 20 subclause 1. What we are referring to a specific provision under the Stamp Act, which provides for Article 20 subclause 4 for amalgamation. I'm not before this court or this order of amalgamation.
Specifically not defined anywhere, you don't have to pay the stamp duty.
That's the judgment of the various courts, including I can think. When there is a fiscal statutes, if there's no specific clause providing for a charging provision, there is no stamp duty payable. That's an established principle of law on that.
Yes, what are the judgments you rely on?
In GK Cotton Spinning and Weaving Mills, paragraph 9, Your Lordship.
Yes.
There will be a complete harmony. However, if we hold instead that clause 5 will apply in all other cases of proposed dismissal of discharge. The learned attorney general seemed to suggest that while this rule of construction is applicable to resolve the conflict between general provision in one act and the special provision in another act, The rule cannot apply in resolving a conflict between general and special provisions in the same legislative instrument. This suggestion does not find support in either principle or authority. The rule that general provision should yield to specific provision is not an arbitrary principle made by lawyers and judges, but springs from the common understanding of men and women that when the same person gives two directions, one covering a large number of matters in general, and another to only some of them, his intention is that these latter directions should prevail as regards
It's a general law.
general thing. Now, given that there is a specific provision under the Karnataka Stamp Act, which is Article 20, subclause 4, which provides for charging how an instrument of amalgamation, the order of amalgamation has to be, stamp duty has to be paid. In that, it only says 3% of the market value of property situated in the state of Karnataka. It does not, or the consideration being paid. Now, the value of property as regards an immoved property.
What it says is where the remaining period of lease does not exceed 30 years, the stamp duty as conveyance, whatever that is referred in Article 21, the same is payable. That's what it says.
Your Lordship, I am before this court for payment of stamp duty under Article subclause 20, subclause 4, not under 20, subclause 1.
20?
Subclause 4. So Article 20, subclause 4 does not provide for payment of any stamp duty on an transfer of lease.
Yes.
So should there be, should have there been a thing, there would have been a specific provision to that extent under Article 20, subclause 4.
Yes.
Article 20, subclass 4 provides, my lord. Apart from that, 53 is applicable. So they have to pay the stamp duty.
And also then the second contention is, there's a set-off of stamp duty that we have sought for, because on the same instrument, we have also paid stamp duty in the state of Maharashtra, in Gujarat. So that stamp duty has to be given a set-off, which we have filed a memo and
this property is situated in Karnataka, my lord.
No.
We have to applicable Karnataka laws.
Unfortunately, what is being presented before this court for adjudication of stamp duty is the order of amalgamation. The stamp duty is being paid on the order of amalgamation, not on the properties that is situated. So it's a two-strong, either on the value of property or on the value of shares, whichever is higher. Now, I have already paid on a higher value in the state of Gujarat. And in fact, in all these merger matters, we have mergers, companies situated in multiple jurisdictions. So the government in its thing has ensured that to avoid multiple stamp duties being paid in multiple states, there's a specific provision under Section 19 of the Karnataka Stamp Act. In fact, on the previous point, this court has in the past has held that no stamp duty is payable on transfer of lease also.
Section 19, where is it?
Yeah. Payment of duty on certain instruments liable to be increased duty in the state of, where any instrument of the nature described in any article in the schedule and relating to any property situated or to any matter or thing done or to be done in the state of Karnataka is executed out of the said state and subsequently received in the said state, the amount of duty chargeable on such instrument shall be the amount of duty chargeable under the schedule on the document of the like description executed in the state of Karnataka, less the amount of duty, if any, already paid on such instrument in any other state. Now, the instrument is the order.
What is it you have paid? What is the stamp duty you have paid?
I have paid I've paid Lordship in paragraph 1. The stamp duty payable in the state of Karnataka is 1 crore 9 lakhs. Yeah. We have paid 84 lakhs in the state of Gujarat and Maharashtra. So that needs to be set off.
What is your
property situated in Karnataka? They, as per the law, they have to pay.
say about that section 19?
There's a judgment. In fact, this court has already passed an order in similar matters in the past.
I'm of the opinion that entire property is situated in Karnataka only. So they have to pay the Karnataka stamp.
It's not about. Look at how you responded in your objections to
Please.
to their pleadings. That they are not liable to pay the stamp duty, as they've already paid in the state of Gujarat for the very same agreement, an amount of rupees so and so.
80 lakhs.
What is the response? What is the response? They filed objections.
Their objection, they're silent about this
Reply,
point.
will reply. Let me to permit. Stamped valuation report.
They have not responded at all on this point.
No, valuation report, I'm filing in 255.
It's not about the valuation report.
No, I didn't file earlier.
When they've taken several contentions, are you not supposed to file your objections to that?
I'll file.
It's not I will file, you should have filed by this time. We don't look at they're taking different contentions. All that has to be answered.
We'll file, madam. That's what they're saying. See, actually, we are Article 20, Clause 4. In case I'll file a detailed synopsis and.
That has to be, you have to respond to all their contentions.
I'll file next date of hearing. And permit me to file this one.
File it in the section, not here.
I'll do it. Copy has been served to them.
Do it. Then government will file a detailed objections to the application filed by the petitioner.
104 also. Same contention, 104.
Let give it to him, whatever it has to be filed, let them file in the section. I think section.
Register file.
List. List. Pause list.
104 also, my lord. Similar case. 104, serial number.
104.
Serial number 19, 18. Connected.
Serial number?
But similar stamp duty matter, no? Similar stamp duty matter. I'll file this here also.
They have filed their objections?
Both.
He has to respond to that.
Yeah, he's not responded to that.
We'll file it.
The same 18 also. Very much.
Here also.
Number 19.
Relates to payment of stamp duty. It's a little different question that crops up for correct consideration. In fact, after the scheme was sanctioned, the stamp duty affidavit was filed and a payment of around 1 crore 23 lakh was made. Subsequent to that, it came to the knowledge of the petitioner that 2 properties were acquired prior to the scheme of amalgamation even commencing. So a subsequent affidavit was filed. And the question that was raised by this honorable court was whether the compensation that would now be received by the transferee company would be liable to stamp duty. That is a question that came up for consideration. If I may submit, I have furnished 2 case laws on 14th of November 2024, wherein, in fact, payment of compensation in a situation of this sort, there is no provision under the Karnataka Stamp Act. That is brought out. If I may draw your lordship's attention, this is of this Honorable High Court in 1,0591 of 2021 minutes.
Karnataka State Highways Improvement.
Yes,
Program.
Milords.
No, before that, let me look at your application.
If I may draw your lordship's attention to the first affidavit that was filed. I had first filed the affidavit on 30th of March 2016. And the stamp duty of 1 crore 23 lakh 79,397 was paid. Subsequently, I filed an affidavit on 6th of December 23 minutes, along with a memo of calculation.
You are representing whom?
The petitioner company. Now it's a transferee company, which is SVG Exports Private Limited.
You purchased the property on 14.
It was purchased by the transferee company, that is the transferor company, that is SVG Hotels Private Limited.
On 14/9/2007.
14/9/2007, my lords, it was purchased. While the scheme, my lords, comes up for consideration in 2014, my lords. So much prior to it was purchased. And my lords, the notification for acquisition is on
Scheme of amalgamation is on 12/3/2015.
Yes, my lords. Lords, the notification is on 18/11/2005.
Now the issue is?
Lords, the issue that comes up for consideration is whether the compensation that would be received by the transferor company or the transferee company now, my lord, whether that would be liable to be levied, whether that would be leviable under the Karnataka Stamp Act under Article 20, Clause 4.
The compensation amount.
Look, whether I would be liable to pay stamp duty on the compensation amount that I would be receiving from the authority, from the KIADB. That is a question.
The land acquisition matters and all.
Lords?
Even other taxes also there is exemption.
Yes, my lords. There is an exemption. So in fact, I furnished the 2 case laws on this point, where it is clearly brought out that these are exempted. And in fact, if I may draw your lordship's attention to the
And even
second.
the people, I mean, if the amount has to be transferred to the other, I mean, if they are NRIs, there also they have this exemption, I think, for this acquired land compensation amount.
NRIs, I'm not aware.
That is, there is, even for them also there is a clause with regard to the taxes and all. Let's see what is the judgment.
Lords, the decision, Lords, the first case law, Lords, on the point is.
Now you received the compensation from the.
I have not yet received, Lords. I'm yet to receive it. Lords, internal page number 7, para 11. Whether the point that would arise for determination in the present matter is whether the award rendered by the arbitrator in terms of Section 3G of the National Highways Act 1956 would be an arbitral award in terms of Article 11 of the Karnataka Stamp Act 1957, requiring it to be stamped in terms of the said article. Lords, the various aspects, the provisions are looked into. And if I may draw your lordship's attention to para number 21, internal page number 14. If I may quote, it is only on account of Section 3G of the NHA that arbitration is provided for in a statutory manner. There is no agreement in terms of Section 1 of the Arbitration Conciliation Act between the land loser and NHAI to submit to any arbitration. Even Section 7(5) of the Arbitration Conciliation Act is not applicable since there is no contract entered into between the land loser and NHAI, where any reference to a document containing an arbitration clause and or Section 3G of the NHA is in existence. Thus, it is only on account of the statute that land loser is compelled to resort to the process of arbitration, the land loser not having consented to any arbitration proceedings. The question of land loser consenting to the requirement of stamping of an arbitral award by being knowledgeable about requirement of stamping does not arise at all. More so, when in pursuance of section 30ZE of the KSA, in the case of award under Article 11 of the KSA, it is the awardee who is required to make the payment in the stamp duty. The state cannot take away the compensation awarded to the land loser by imposing a duty to make payment of stamp duty on the said award, which is an additional burden on the land loser to obtain just compensation on account of loss to his land. It is also clear from the fact that while calculating the compensation payable, there is no calculation of the value of the stamp duty payable on the award made. The requirement to make payment of stamp duty on the award would amount to reduction of just compensation, which is not permissible. In view of the above, though there is an arbitration proceedings and though the Arbitration Conciliation Act is made applicable to the said proceedings, I am of the considered opinion that the award of compensation rendered by the said arbitrator would not come within the purview of ambit 11, Article 11 of the Karnataka Stamp Act, which deals with the arbitral award and stamping thereof. Just because the award is rendered by the arbitrator under section 3G of the NHA would not suffice more, since this award of compensation by the arbitrator would have to be rendered by the land acquisition officer under the Land Acquisition Act or any other similarly situated enactment. Such an award rendered by the land acquisition officer under the Land Acquisition Act or any other similarly situated enactment is not amenable to payment of any stamp duty. I am of the considered view that the award rendered by the arbitrator in terms of section 3G5 of the NHA Act cannot be rendered as an award, cannot be treated as an award under Article 11 of the KSA as to make it amenable for payment of stamp duty by a land loser or on an award or compensation which the state or the union is bound to award for acquisition of land by exercise of powers of eminent domain, which in turn is an exercise of sovereign powers. Looked at from any angle, the levy of stamp duty on an award of compensation passed on account of acquisition of land, in my considered opinion, would be highly unconscionable.
What is the next judgment?
The next judgment is also of this Honorable High Court. Writ petition 29440 of 2019, Karnataka State Highways versus KMC VDB. If I may. From para 6, internal page 6. I have considered the submissions made by the learned counsel for the petitioner as well as the respondent. When the award of the arbitrator deals with a movable property or immovable property by virtue of charging clause contained in Article 11 of the Karnataka Stamp Act 1957, such awards are bound to suffer stamp duty before it is brought for execution. In the case on hand, as rightly contended by the learned counsel for the respondent, the award does not deal with either movable or immovable property, but it awarded liquidated damages payable to the respondent arising out of a construction contract. Therefore, the award does not attract stamp duty, as no provision is made in the Karnataka Stamp Act 1957 to collect stamp duty on an award which deals with award of damages, and this court cannot supplement the omission in the legislation by including an award which deals with a grant of damages.
Next judgment, I don't think is applicable to you.
Any compensation, my lords.
No, that is a different aspect.
Yes,
sir. That is Justice Nataraja has dealt it a different case.
This is a construction contract where compensation is awarded.
Where it is for damages, it's
Yes.
not about a movable or immovable property. That's what he said.
So my humble submission is, so far as the compensation which would be received by the transferee company for the acquisition in the hands of the transferor company, I would not be liable to pay stamp duty. Humble submission is I have filed an affidavit.
You say that is submitted to the petitioner would be liable to pay the stamp duty.
I am liable to pay the stamp duty. There are 3 properties in that particular place. 2 properties have been acquired.
2 issues here. You say about 2% and 3%.
That is another aspect that they have raised. They raise that I am liable to pay 3%. But my submission
First
is
of all, when your contention that you are not at all liable to pay.
No. My humble submission is this. So far as the land acquisition, for which I am entitled to compensation, I am not liable to pay. There are other properties on which I am liable to pay stamp duty. Now, the other question that arises for consideration is whether it is 3% or 2% on the property.
What are those properties? What
Yes,
are those
if I may draw your
applications?
lordship's attention to page number 4 of the affidavit dated 6th December 2023. I have filed an affidavit on 6th December 2023.
This is COP 133 of 2014.
133 of 2014.
Now, what
Yes.
are the applications in this?
The affidavit that I filed is for payment of stamp duty for the purpose of drawing up a decree. So I have filed the affidavit indicating the stamp duty that I am liable to pay under the Karnataka Stamp Act. If your lordships has got the affidavit, which I have filed on 6th of December 2023, if I may draw your lordship's attention to page 6th of December 2023. If I may draw your lordship's attention to the internal page number 4. Milords, in that I have indicated the schedule of assets. Land at Bomsandra Industrial Area, Jainagar 2nd Block, Bangalore. Survey number 40/3 of at Talgatpura Village, Uttarahalli, Hubli. Now, these three properties, Milords, the valuation would be 25 crores, 87 lakhs, 73,150. And the building at the above places would be 25 lakhs, 25 crores, 63 lakhs, 9,834. Total would be 51 crores, 50 lakhs, 82,984. And movable assets I've indicated in part 2, which are the plants and equipments, the furniture and fixture, the vehicles, the cars, the office equipments at the hotel premises, and the computers, electrical equipment and installation, which comes to a total of 10 crore 38 lakhs 86,842. The total of both coming to 71 crores 82 lakhs 64,824. Milords, on this, Milords, I am liable to pay 2%. Milords, the date for reckoning the percentage would be the date when this court passed the order, Milords. Milords, on the day when this scheme was allowed, Milords, by this honorable court, it was 2%. So my humble submission is, as on that date, I am liable to pay 2%.
As on which date?
As on, Milords, the date that is 12th of March 2015, Milords.
That's a scheme, that's a date where the amalgamation.
By virtue of this court's order, the amalgamation comes into force. And as on that date, as per the existing stamp duty,
What was the
2%. Milords.
And basing on what they are saying, 3%?
Milords, that is not, that is made
Because
without.
that is sale is on 14/9/2007.
No, Milords, in fact, subsequently it was increased to 3%. I think on that basis, they are making that.
It is announced for 3%. Now it is a 5%.
No, as on 12/3/2015, it is how much?
As on that day, the 2%. No, as on that day, the valuation, what they did at the time, it was a 3%, they did accordingly.
When the property is registered, what would be the, whatever is stamp duty that is applicable?
Milords, it's on the day when it comes into force, on the day when this court sanctions the scheme, Milords. From that day, it becomes the effective date, Milords. We start working on the amalgamation of the accounts of the company, the balance sheets, the profit and loss accounts, all are merged, and the company merges into the transferee company for all purposes.
On that.
Milords, Milords, that is the effective date. If I may draw lordship's attention also to the scheme, Milords, there are two dates, Milords. One is the appointed date. That is a date when both of them enter into the scheme, but it is not given effect to.
As far as department is concerned, whenever your
there are only 2 dates.
Whenever your document is registered, as on that day, what is the prevailing market value, prevailing stamp duty, that has to be paid by anybody.
Milords, my humble submission. There are only 2 dates that can be considered. One is the appointed date. The appointed date is the date when both the companies, that is the transferor company and the transferee company, approve the resolution accepting the scheme of amalgamation. That is for all purposes. They accept that we would give effect to this, subject to the court sanctioning the scheme. When the court sanctions the scheme, everything comes into effect, and that becomes the effective date. There cannot be any date other than the effective date.
Let's take it as 12/3/2015. When are you getting it registered?
No registration. We pay the stamp duty, and a decree is to be drawn by this honorable court. A direction has to be given to the decree branch for drawing up the decree.
What do you say?
But it's very much clear. The moment, according to the valuation report, that day, what it prevailed, that he has to pay the stamp duty.
You have calculated as on which date?
It was written here in my valuation report, my lord, 2nd page. Shall I read it out? It's in Kannada language. SPG Export Private Limited ಟ್ರಾನ್ಸ್ಫರ್ ಕಂಪನಿಗಳು ವಿಲೀನಗೊಳ್ಳುತ್ತಿದ್ದು ಸದರಿ ವಿಲೀನ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಚರ ಮತ್ತು ಸ್ಥಿರಾಸ್ತಿಗಳ ವರ್ಗಾವಣೆಯಾಗುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಯೋಜನೆಯಲ್ಲಿ ಸ್ಥಿರಾಸ್ತಿಗಳು ಇತರ ಜಿಲ್ಲೆಗಳಾದ ಬಸವನಗುಡಿ ನೋಂದಣಿ ಜಿಲ್ಲಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದು ಉಲ್ಲೇಖ 3ರ ಪತ್ರದಲ್ಲಿ ಸದರಿ ಜಿಲ್ಲೆಯ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳಿಗೆ ಸ್ಥಿರಾಸ್ತಿಗಳ ಮೌಲ್ಯಮಾಪನ ವರದಿಯನ್ನು ನೀಡಲು ಕೋರಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 6 ಪತ್ರಗಳಲ್ಲಿ ಸದರಿ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು ಸ್ಥಿರಾಸ್ತಿಯ ಮೌಲ್ಯಮಾಪನ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಜಿಲ್ಲಾ ಮೌಲ್ಯಮಾಪದ ವರದಿ ಕಚೇರಿ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಸ್ಥಿರಾಸ್ತಿಯ ಮಾರುಕಟ್ಟೆಯ ಮೌಲ್ಯ ಮತ್ತು ದಿನಾಂಕ 14/12/2022 ರಂದು ಸಲ್ಲಿಸಿರುವ ಪ್ರಮಾಣ ಪತ್ರ ಮತ್ತು ದಿನಾಂಕ 23/11/22 23/11/2022 ಕರ್ನಾಟಕ ತಾಂತ್ರಿಕ ಸಲಹಾ ಸೇವಾ ಸಂಸ್ಥೆ ಟಾಕ್ಸಿಕ್ ರವರ ಮೌಲ್ಯಮಾಪನ ವರದಿಯನ್ನು ಸ್ಕೀಮ್ ಆಫ್ ಅಮಾಲ್ಗಮೇಷನ್ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಒಳಗೊಂಡಿರುವ ಚರ ಮತ್ತು ಸ್ಥಿರಾಸ್ತಿಗಳ ಈ ಕೆಳಗಂಡೆ ಮುದ್ರಾಂಕ ಶೌಲ್ಯವನ್ನು ಆಕರಿಸಲಾಗಿದೆ. That's what it says. So whatever the affidavit they filed on 14/12/2022, apart from 23/11/2022, accordingly they have verified and valuation has been done. The movable assets is about more than 10
So
crores.
except filing this valuation slip, you have not, you won't file any.
I'll file objections next data.
Not, you should have done it.
I was not aware, my lord. That's what they, and even though I'll go through the
submit.
judgments also what he says.
If I may submit, in fact, the valuation that we furnished, the valuation that they have given, the valuation that they've given is much higher than the valuation that we have given, my lords.
It's only percentage.
No, even otherwise, even in terms of value, my lords, even in terms of value, the value that they have given per square feet is much higher. My lords, we had calculated at that point in time, keeping in mind the 3 properties which were not acquired. We were, for a moment, it slipped my mind. Subsequently, my lords, the 2 properties are removed since they have been acquired. My lords, even then, my lords, we have taken that into consideration, their valuation. We have taken that into consideration, my lords. Even then, my lords, I have filed an affidavit subsequent. I would be liable to pay 19 lakhs and odd based on their valuation in respect to the property. But my humble submission is the point that comes up for consideration is whether it's 2% or 3%. My humble submission is that it would be 2%. The day when, not when I file the affidavit, the day when this honorable court allows this scheme. In fact, I've also filed an affidavit to that extent. If I may also draw your lordship's attention to the affidavit, the memo that I have filed on 7th April 2024, my lords. The petitioner herein furnishes, submits the valuation report. By way of clarification, the petitioner herein is filing its affidavit in respect to the valuation report filed by the state government.
So number one copy.
You file so many affidavits. For any of these affidavits, they don't file their
No, no, I
response to this.
Consolidated last time. After the last date of hearing, I made a consolidated file and I have given it. Stitch ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
No, it's not about, I'm not saying that you have not given them. They don't respond to any of it. Just simply in all the cases filing one valuation report.
In that sense, I'll file complete detailed everything objections.
Has to be filed.
I'll
in all
file,
these matters.
I'll do.
Otherwise, what is your stand? How the court will understand?
Agree, I agree. I'll file a detailed one.
In fact, in this I have brought out para 4 minutes. It is submitted that in respect to the movable properties, the petitioner herein by its affidavit has valued them at 10 crore and odd. Well, the state government, IGR, has valued the movables at through TechSoc.
What is the difference?
Difference is at rupees 10 crore 66 lakhs. We accept that 30 and odd lakhs. We accept. There is a difference of rupees 27 lakh 13,158, which the petitioner herein accepts and accordingly.
What is the basis for you for arriving at that amount? You have to say.
I'll do.
My humble
Copy
submission
maybe
is
not
not.
today.
Whatever is the difference, in fact, only for the purpose of ensuring that this is true, we have accepted to pay at their valuation. And 2% is what is applicable. I will also try to produce some case. All through that is a procedure. This honorable court in every case has levied the stamp duty as on the day when the scheme is allowed. Yes, that is a.
I will file a detailed one, but 3% is applicable. That time it was increased. I'll file a complete objection.
In fact, in my affidavit also have indicated.
Please come. When counsel appearing for the applicant submits that, the applicant has to pay the stamp duty
Copy
at
code.
2%. At 2%, whereas as per the valuation they placed before this court, they have considered it as 3%. It is stated that as on the date, the scheme was formulated by this court on 12/3/2015. it is 2% is a stamp duty, and the applicant has to pay the same on the said amount. When it comes to the movable properties, it is valued at 10 crore 38 lakhs 86,842 by the applicant, whereas the respondent, the stamps department had assessed it at 10 lakhs, 10 crore 66 lakhs, and there is a difference of rupees 27 lakhs 13,158. The learned government pleader had placed before, on behalf of the department, has placed before the court the valuation report, except that none of the contentions or none of the elements that are made in the affidavit by the applicant, the respondents have not filed any objections to that. What is this dated?
No, it's dated 7th April 1st April 2024. 1st
So
April.
the affidavit that is filed dated 1st April 2024, the respondent shall file the detailed objections, if any, by the next date of hearing.
I furnished the entire compilation also, Manoj. Just furnish again.
Yeah.
One more.
This is matter on 6th of March.
Till number 28.
I appear for the petitioner. Manoj. Now, this is a scheme of demerger where, Manoj, I am not liable to pay any stamp duty. The objection that has been raised by the government is I am liable to pay stamp duty.
Have they filed objections in this?
Milaj, in fact, I have filed an affidavit of clarification also. They have compared it as they have treated it like a scheme of amalgamation. The stamp duty differs. Milaj. A clarification I have filed on 15th November. A perusal would make it clear that no stamp duty would be liable to be paid. Milaj. If I may draw your lordship's attention.
My humble submission, sir. 20 and 21 file is not locating in our office. So kindly.
The last time we served it on them.
New served matter is not available in our side. That's the main issue. 2015 matters somewhat. By mistake, it was happened.
So you those two matters also same date. It is submitted that the file is not traceable in the government advocate's office. Petition shall serve a copy again.
No, we have served it.
And
for us.
appellate
We have
detail.
served twice we have served. Milaj. Last week I've served and I've taken the acknowledgement
So
also.
if you want an order, it should.
I will serve one more copy right away. Milaj.
Give him-
Good.
Please.
Milaj, I've served another.
And I file a detailed objection also.
Land council has served, but the petitioner had all served the copies from the government advocate. The same date. Next.
Till number 40.
Obliged. Sir, 151.
Respondent spoken to fix the time. I'll share the calculations with my clients and to his office tomorrow. We'll sit down next week and have a
Date.
Tuesday.
My lord,
Monday.
they'll share the calculation on Friday tomorrow, my lords, and we'll sit down on Monday or Tuesday, whichever is comfortable.
They will share the calculation or you?
Tomorrow.
They will share.
Yes, my lord.
Land council appearing with respondent submits, they'll share the calculation memo, with the official liquidator on by tomorrow. And the respondent will discuss with the official liquidator on this on 3rd February, and the outcome will be placed before this court. This is matter on 6th Thursday.
Sorry, my lord, is it serial number 47, my lord? I'm
Till
sorry.
number 40. sir.
6th Thursday.
Till number 41.
Yes, next.
41. Till number 41.
This I would about 2 weeks to secure instructions in this was also possible. Understand.
What is this 41?
My lords, this is the rent matter and they have to pay the rent, but they are not coming forth, my lords. The same matter as always.
This I would need some time.
Why?
Mostly because I'm not able to get, since this matter got decided last night, I'm not able to secure instructions. If I can get about 2 weeks time, I'll get proper instructions, my lords. Right.
How much is the amount?
4 lakhs.
My lord, it would be go up to 10 lakhs, my lords.
The principal is 4 lakhs. interest is about.
Then pay, when are you paying the principal?
Sorry, Milos?
When are you paying the
I,
principal?
I've taken instructions on that. I will not be able to make a statement without.
Okay, for instructions, why would it take 2 weeks?
Because I have tried.
We are now on that, forget about the interest part.
Please.
On the principal 4 lakhs, when are you going to pay?
Because I have to take, I cannot.
Get
make the
instructions,
statement.
will, any of the other matter is coming up on 6th, you have to come to the court, get
Please.
instructions. List this matter on 6th,
I'm
by the
good.
time accounts for the respondent shall get specific instruction. When the admitted amounts are going to be, will be paid. Huh?
Not admitted to that.
No, I didn't specify what it is.
Please.
Admitted amounts and will be paid. Yes.
47.
So my lords, fund situation in this matter of condonation of delay is 4.3 crores, but that is only for preferential payments. No, my lord,
It's what he wants is information.
for them,
nothing
it's,
else.
the sum would be 0, my lords.
It's not for them.
Okay.
As of now, what it is. Anyhow, you have to follow rule 178.
My lords, this is a typical matter.
No, this matter only you're
Yes,
referring
my
to,
lord,
next
this matter.
matter.
Yes, my lords.
Uh,
So, my lords, even if their delay is condoned, what has happened, the secured creditor is standing outside winding up. They sold the property. Now, as per Supreme Court judgments, they have to give us only the pari passu proportion of the workers. They gave that preferential payment. Even if I'm left with something, I have to return it back to them. Now, my lords, all these unsecured creditors will not get anything. They delay may be condoned, my lords. I'll adjudicate upon it.
That's on the merit
My
of the
lords,
matter.
my lords.
So we'll not go into that. According to you, the money that is with you as of now is 1 crore.
4.3 crore, my lord, but that has come through. Yes, my lord, sorry.
We are not going into that.
Yes,
You have 4.3 crore with you and now they have come up with this application.
Yes, ma'am.
Will condone the delay subject to rule 178.
8. My lord, just this never happens. This money is actually written in High Court order only for preferential payment. It never happens. But this time it happened, my lord.
Now you know what is the amount, Mr.
Yes,
Counsel?
yes, my lord. Yeah, about 4.3 crores is what,
4.3 crores.
yes, my lord.
Yes. Do that application. This application 357 of 2024 is filed. To condone the delay of 2,865 days in filing the claim before the official liquidator. It is stated that the applicant had supplied goods and material to the respondent's company and the applicant is a creditor. The company is a due of an amount of rupees 27,64,352 to the applicant at the time of its winding up. Though it is stated that the official liquidator appears to have called for the creditors to prove their claim by paper publication, the Times of India and Vijaya Karnataka on 28/3/2016, fixing the last date of submission of claims to the official liquidator as 27/4/2016, which is not within the knowledge of the applicant. They came to know about this only when the deputy official liquidator issued a notice dated 12/3/2024 calling upon the applicant to submit its claims, if any, by way of an affidavit of proof. And accordingly, the applicant has submitted his affidavit on 1/4/2024. It is stated that the applicant came to know on 12/3/2024 when he received the notice from the deputy official liquidator, High Court. In this process, the delay of 2,865 days occurred. In view of the same, this has come up with this application under section 177 of the Companies Act and to condone the delay of One, 2,865 days. The official liquidator submits that. Another rule.
178 of company code rules.
No?
178, my lord, 178 of company code rules.
Yes, yes, yes. The official liquidator submits that as per rule 178. The applicant, when subject to 178, if this application is allowed, the official liquidator has no objection. Then counsel appearing for the applicant also submits that as that his rights would be subject to rule 178 of the company rules 1959. Accordingly, the delay of 2,865 days is condoned, subject to, and the rights of the applicant are subject to section rule 178 of the company rules.
Obliged.
So, yes, next.
Number 48.
I appear for the petitioner, my lord.
Yes. Yes.
Lord, it is our case that, my lord, the first respondent, which is a company registered under the Companies Act, my lord, is become insolvent for not honoring, my lord, a commitment due. I just take, my lords, to the memorandum of understanding, my lord, Annexure D, page number 37.
Page number
37, please, my lord, Annexure D. Lord, this is a memorandum of understanding between the petitioner, my lord, and the first respondent. My lord, at page 38, please have a look at, my lord, last 6 lines, my lord. Page 38. Lord, this was an agreement where, my lord, the petitioner would facilitate certain financial facilities to be made available to the respondent company, in relation to which, my lord, there was an agreed amount that was to be paid. Last 6 lines, my lords, may kindly see in page 38. The second party will inform the first party the indicative interest rates on and the processing fee after ascertaining from the financial institution. On accepting the same, the first party will sign the loan applications. First party hereby agrees to pay total service charge of 3.5% of the loan sanctioned amount, takeover or additional loan, plus applicable service tax. Page 39, my lord.
Yes, yes.
First party agrees to pay 1.75% of the loan sanctioned amount to the second party immediately upon the receipt of the loan sanction letter from the financial institution bank and acceptance by the first party on the interest rate and terms and conditions of the sanction letter. Now, the sanction, my lords, will kindly get at Annexure F, page number 43.
Yes.
My lord, this is the sanction letter, my lord, given in favor of the respondent company.
Yes.
On 11/12/2015. my lord, which has all the particulars. Therefore, my lord, as per the, my lord, agreement, they are required to immediately, my lord, release 1.75 of the loan sanction amount. And my lord, balance 1.75 has to be paid, my lord, after the release has actually taken place. Now, my lord, the facility is for 11.91 crores. That was, my lord, organized.
Yes.
My lord, 3.5%, my lord, works out to 41 lakhs 71,195. My lord, half of that which they have to immediately pay after, my lord, the loan sanction letter would be half of that. That is approximately about, my lord, 21 lakhs 75,000.
Yes.
A statutory notice was issued. Even after issuing the statutory notice, my lord, this payment is not made. They are not in a position to show that, my lord, this payment can be made or the funds are kept ready. Kindly see, my lord, the legal notice which we have issued at Annexure G, page number 57. Now, under section 433 of the previous old Companies Act, my lord, if they are unable to pay any amount, which is, my lord, clear from the records, my lord, prima facie a clear case for insolvency is made out. The requirement is, my lord, statutory notice must be issued, my lord, which we have issued at page number 57. It is duly served. And my lord, they have also sent a reply as per page number 63.
Yes.
So therefore, my lord, requirements of section 433E and F have been complied with me. And therefore, my lord, now what they would say is, no doubt there is a sanction, but there has been no agreement between us. And so therefore, this is not an amount which we can pay. My lord, when the amount is clearly, my lord, if it was an oral negotiation or a oral transaction or a transaction which we had to decipher through letters, my lord, this could have been, my lord, a possible argument. My lord, everything is crystallized in the form of, my lord, an MOU at Annexure D, which my lords have just now seen. So therefore, my lord, debt is prima facie clear, which they have to pay.
Yes.
Therefore, my lord, this petition for, my lord, winding up the respondent company, as it is unable to pay, my lord, its creditors and discharge the amounts.
The submission to your lordship is that as per the MOU itself, the liability has not come. May I request your lordship to kindly turn to page number 39 again, my lord. The first party agrees to pay 1.75% of the loan sanction amount to the second party immediately upon the receipt of the loan sanction letter from the financial institution bank. And your lordship may kindly see the word used, and acceptance by the first party on the interest rate and terms and conditions.
You are reading 39?
39, my lord. Top. The first party agrees to pay 1.75 of the loan sanction amount to the second party immediately upon the receipt of the loan sanction letter from the financial institution bank and acceptance by the first party. So if the loan sanction letter and the terms and conditions mentioned therein are accepted by the first party, then the obligation, as per this document, obligation would arise. Now, your lordship may kindly turn to page number, Annexure F, page number 43. Here, the second column, my lord, page number 43, Annexure F. Amount sanctioned in this LIBOR, your lordship, get it at the right side, second tabular format. LIBOR 500 point BPS. Note, concession in the interest for VRFL limit the head office wide letter number so-and-so dated 8/12/2005 has informed that the matter will be taken up separately with the competent authority. And the decision of the committee will be communicated accordingly. So it is not final. Then your lordship may kindly turn to page number 45, middle portion. Note, processing fee. That also subject to it is not finalized, that they will charge the respondent company had never agreed to pay the processing fees. So the terms and conditions have not been suitable to the respondent company. It has not accepted the sanction letter. And as per the notice itself, your lordship may kindly turn to page number.
There is no concluded agreement between the parties.
The liability would arise only if the respondent company accept the loan sanction letter. It has not been accepted. So the liability, there is no cause of action for the petitioner to demand that amount. The cause of action for the petition to demand that amount would arise only if the sanction letter and the terms and conditions are accepted by the respondent company. Respondent company admittedly not accepted it. And your lordship may kindly turn to page number 60, that is the annexure G, notice issued by the petitioner. Page number 60, last 4 lines, my lord.
Yeah.
Therefore, instead of accepting the, your lordship got it, my lord, accepting the sanction of the credit facilities, there was unnecessary delay from your end, even though there was no real difference between the terms that required by you and terms offered by Vijaya Bank. So he admits that, the petitioner admits that the loan sanction terms and conditions were not accepted. What he says that he's attributing that it has not been accepted for some, I'm delaying it. Then your lordship may kindly turn to next page. First, next page, paragraph, last 2 lines, my lord. There appears to be a stalemate between you and the bank. Our client has nothing to do with the same.
Are you reading?
61, page number 61, first para, end, my lord, end.
There appears to be
There appears to be a stalemate between you and the bank. Our client has got nothing to do with the same. So this liability has been disputed. There is no liability has not arisen because the terms and conditions are not concluded. Vijaya Bank itself says that we are corresponding with the head office. We'll let you know later. So this sanction letter has not been accepted. Terms and condition has not been accepted. Therefore, the liability to pay this 1.75 never arose. Subsequently, because of the terms and conditions have not concluded, not accepted, loan amount has also not been released to the respondent company.
It is not released.
Not released.
Where did you say so? Where is your reply?
No, that is, he says that loan is not released.
Your reply.
Reply. Paragraph number 3, my lord.
Page number?
Page number 64. My client instruct me to state that subsequent to the above, it was issued with this sanction letter dated 11/12/2015 by said Vijaya Bank, and having regard to the several terms and conditions mentioned therein that are not beneficial to it vis-a-vis the terms and conditions imposed by Kotak Mahindra Bank. It had sought clarification vide its letter dated 15/12/2015. As the said Vijaya Bank did not furnish appropriate clarification, and on the other hand, apart from reiterating the terms and conditions in the sanction letter and that concession would be granted only after availing the loan, my client had caused one more letter dated 22/12/2015 to the said bank, which remain unanswered. My client instruct me to state that as the terms and conditions, rate of interest and other factors contained in the sanction letter issued by Vijaya Bank are not beneficial and as per its requirements, duly intimated to your client that said bank while making application dated 5/11/2015 and thereafter it was constrained not to accept avail the said loan granted by the Vijaya Bank. My client instruct me to state that the loans offered by Vijaya Bank are with hidden charges and uncertain as to reduction, concession, and with the bait that only if the loans are availed, reduction, concession would be considered, and thus there being no guarantee in reduction / concession in the interest rate and other charges. Even though the said facts have been highlighted and brought to your client notice, instead of resolving the issues, your client has chosen to exploit the situation to suit his ulterior motives and interest, and thus acted detrimental to the interest of my client, which in the totality of the facts and circumstances your client ought not to have been done. So the though MOU is there,
That stage. Lord, that stage. With respect to that, if I may make one submission, my lord. My lord, as I. Please, ma'am. Please, my lord. And. My lord, relief is for declaration also, so it survives, my lord, my condition. Lord, the previous mistake which my lord stated, my lord, that why I pursued a new suit instead of presenting. Please, my lord. That is one reason, my lord, and if my lords may look at the endorsement, my lord, which was given. My lord, plaint came to be returned on 25/9/2006, but endorsement of the trial court was given on 21/7/2007. So I filed my new suit long before the endorsement was given, that is on 2/1/2007. Lord, at the time of, please. Please. But I withdraw it, my lord. Immediately I withdraw it once I get to know that the document, so there's no intentional wrong on my part. My lord, one only thing is claiming, my lord, this, on this technicality, my lord, I may not be, I was not able to. My lord, this is on 18/1/2017, my lord. Please, my lord, at page 114.
The client was returned on 25/9/2006. Lord, thereafter on 31/1/2007, Lord, he has received the claim. Lord, till today, Lord, the plaint is not present. Lord, as per the order passed by the court, Lord, even otherwise, Lord, they ought to have filed an application. Lord, before the Lord, original court, that is in OS number 465/1987. Lord, that since an application formally, my lord, the claim, original claim is not even filed. My lord, the question of again, my lord, permitting the plaintiff hearing to make an application. That is what, my lord, that is what. It is not filed. My lord, let them show that it is filed. They have filed an application, Lord, in OS number 57/7.
The records are sent, my lord. The records are sent. They are transferred to this court.
They have made that application, Lord, in OS number 57/2007, which was a subsequent suit, second suit. Lord, all these applications, what they have made, Lord, are in the second suit, which was already disposed of in view of the memo being filed by the plaintiff, Lord, seeking the prayer to withdraw it unconditionally. Lord, they have withdrawn the suit, my lord, and after withdrawal, my lord, the suit was withdrawn on, my lord, 1/9/2007. It was withdrawn on 1/9/2007. My lord, thereafter, after a lapse of 4 years, my lord, on 6/1/2011, my lord, they have filed an application for calling the records of the original suit, my lord, that is, which was filed in the year 1997. Lord, they did not pursue for all, Lord, 4 years, even after withdrawing the case. Lord, the client was returned on 31/1/2007. Lord, if we count the limitation from 2007 till 2011, Lord, as per Article 137 also, my Lord,
My lord, my lord, I have two more submissions to you. My lord, that is not right, my lord. When the entire documents are sent to the new court, my lord, what happens, my lord, if my number is 465/1997, the new court will allot a fresh number, then the suit will continue. There was no fresh number allotted, my lord, so I could not have continued my old suit. My lord, and if, as my lords may take page 117, my lord, page 117 of the impugned order, at para 5, my lord. Para 5, my lord. Lord, materials on record disclosed that on 2/9/1997, 2/9/1997, plaintiff had filed a suit bearing 465/1997 on the file of so and so, so and so. And in the said suit, an order was passed for return of plaint on 25/9/2006. Next, my lord, an endorsement was signed by presiding officer on 21/7/2007. My lord, if this date may be looked into, my lord, the date on which I filed my new suit was 2/1/2007. In 2/1/2007 on the date of my new suit. Endorsement was issued on 21/7/2007. Immediately, my lord, on 1/9/2007, I withdraw my new suit. Please, my lord.
So whether the division officer has signed that on what date is not at all relevant. It will not be right to file another suit.
My lord, the right would not be given, my lord, but when the documents and the records have been transferred, now I may be permitted to continue my new suit, my lord.
Taking on 2017 till the issue on.
I have filed my lord, from 2017, my case is closed. I had no remedy, my lord. Please, my lord. Please, my lord. My lord, my case was active that time, my lord. I was continuing. 1/3/2016, my lord. The case, please, my lord. My lord, that submission, my lord, one more. There's one more judgment. This judgment may be considered and any order may be passed. My lord, one judgment.
They submitted, my lord, even today, my lord, I have not presented the claim.
My lord, the entire documents have been sent, so there's no requirement of me to file a fresh. My lord, in this, my lord, if Order 7, Rule 10A, my lord, if it has not been complied, so then the plaint cannot be returned, my lord. May look at paragraph number 13, my lord. My lord, when the plaint is returned, my lord, the judicial officer, my lord, should endorse on the plaint stating that to which court I should go, and the date should also be mentioned in that manner. My lord, I have withdrawn it within a period of 2 months, my lord. My lord, on this technicality, my lord, from 1997, I have not been able to adjudicate on merits, my lord. In 2014, my lord, even PW1 evidence is led, my lord. My lord, PW1 evidence is also led. My lord, the PW1 evidence is at, my lord, one submission is that is not because of my lord, when the delinking was allowed, my lord, when the delinking was allowed and I was permitted to go ahead with my old suit, they are the one who filed. My lord, my submission is on that technicality, my lord. It was a formal application. Formal application. It was a, the 2016 order. That was my lord, that was a formal application, my lord. My lord, this court has the powers, my lord, because, my lord, ultimately, my lord, the suit has to be decreed on merits, my lord. My lord, please. My lord, we were ready for the arguments, my lord. Please, please.
Then again, 23 also, 2 weeks time is granted to do the needful. A week's time is granted to do the needful in 2024. Finally, you realize that on 29/2024, application for substituted service. What are the most practices in the property market? From the docket address.
Lord, the service, the address part, my lord. My lord, what my humble submission, my lord. Lord, only last submission, my lord. My humble submission, my lord. The court may fix a time frame for the trial court. My lord, case should be decided on the adjudication on the merits, my lord. I have not been given single chance. I bow down, my lord. I bow down. My lord, as soon as the documents came to the new court, I was vigilant enough to withdraw my new.
And also you find that the design officer on the given the plaintiff is so presenting the evidence. At five, another thing, case number 57/2007, and got for 57/2007. And thereafter, is withdrawn, the latest thing that was about 57/2007. We wanted to pursue case number 465/97. Later, on 6/2011, an application filed. Follow the record in central domain. Move. Finally, an application filed with the payroll number 465/97 from the court of voice number 2007/2007. No, 15 for filing, and the order was filed on 14/2011. And the same was allowed on card. And directly the office to separate the voice number 465/97. Voice number 57/2007. And the percentage is submitted to receive the voice number 465/1997. That order was taken by the defendant before this court by filing everything involved.
Page number 107, petition 2849.
By filing everything number 2849/2014 days. Okay, and the same disposed of by order, they disposed of the power. The issue is very disposed of the entire legal law. But the liberty is given to the respondent of plaintiff to make necessary application for number 460/1997. Which is number as well as the 40/2014. And the benefit application is filed. This was the code, consider the application on the in accordance with that. Then passing to the submit. Now the court, without now the other taking that after the order of the court.
I am permitted to submit before this court.
No, they can't hear. Yes,
I already caused a legal notice to the party,
where is that?
intention of retirement, but the acknowledgement is not received by me. Would it be?
File the acknowledgement, then we'll consider delete from dismissal, and the counsel for the petitioner has filed a retirement memo and the acknowledgement is not filed. For filing of the acknowledgement, this is matter on 3rd of March. Yes, next. This is matter tomorrow, already 4:47. Yes. What is this? Switch on is mic. Switch on the mic.
At the time of the filing the revision petition,
Whoever is sitting.
got the NOC,
Ensure that the mics are on. Yes.
got the NOC from the previous council and filed the application and got the stay order. Thereafter, the matter was posted 2-3 days on the previous council name, but not my name. So that mistake is the non-prosecution of the appearance, the dismissal, the writ petition, with the revision petition. So now I have filed the restore application pending. The Monday will be listed that matter. Kindly you posted to 2 weeks. I will file the objection and along with the orders. Please time for 2 weeks.
Let's, now, no stay, nothing is pending. They have filed the
Order is
application
there.
after 1,300 days, my lord. The application for recalling that order, they filed after 1,300 days. And now they are filing an application before the Chennai court for recalling, but no order has been passed so far, my lord. And
This amount is deposited where?
in Bangalore High Court, my lord, yeah.
Where is that order?
The deposit of thing,
By which order of this court the amount is deposited?
orders of this honorable court only, my lord.
Date.
Date.
The last date I will produce the documents, along with memo. Page number 15 to 19, 20, my lord.
Why should the court condone the 1,400 days delay?
No, the list listed in the previous council. I appear for NOC. File
What
the-
problem is that? If you file wakalat, when did you file the wakalat?
Not at the time of the writ petition, got the NOC, then filed the application and got the stay. Thereafter, the listed in previous council only, not my name. That's the problem. So restore application now filed with the condone of the delay application. When came to know about that disposal of the matter, immediately filed the condone of the delay application along with the restore application. The same is pending. Mostly Monday, it will be list, please. I will file the objection along with the order after 2 weeks, please.
No,
Amount deposit was on 13/1/2017.
without even hearing this, his application.
Yes, my lords.
And why should, how this court should pass such an order?
Lord, because no appeal or no case is pending before any court, my lord, because it has reached finality. Now the amount has to be released to the respondent only.
This case.
This case is already disposed.
This case we disposed, my
And
lord. Repetition has
undertaking
been
memo
disposed.
also filed the page number 4, last time of filing the memo. along
This
with the document.
repetition has been disposed.
Page number 4.
What is that he wants now?
Now the amount has to be released in my name, my lord. Now because the amount has been, now nothing remains. Now the amount has to be released to the respondent only.
Where is that final order?
Final order is there.
Oh, he has filed an application to set aside the.
Not here, lord. He has filed in Chennai court. Appeal, this, on money recovery suit, he filed an appeal before. Here, he filed a writ petition, execution petition. Against execution petition, he has filed writ petition.
No, what is writ petition number 65248 is already disposed of.
Yes, yes, my lord.
Already disposed, yes.
Then
He has deposited in this.
that I understand. What is that you have
Meanwhile,
filed?
meanwhile, I have filed the one more revision petition before the Chennai High Court.
That is irrelevant.
Yes.
Before this court, there is nothing pending.
Nothing pending.
Yes. The IA number 1 of 2024 is filed to release an amount of rupees 50,000 that is deposited by the petitioner during the pendency of the writ petition, which was disposed of by order dated 12th February. Which was dismissed by order dated 12th February 2019. In view of the same, the amount that is deposited as per the interim order dated so and so, the respondent is at liberty to withdraw the same. Accordingly, IA is ordered.
This case, my lord, if your lordship permit, there is, I have not written in a correct number of days. It is the only objection. The petitioner, sole petitioner died and I.
Petition is permitted to carry out the objection. Is this matter on Tuesday? Next.
Lots. There is a minor office objection in the paper publication application. I may be permitted.
How many times it will come like this? It has come before also.
No, I'm not the regular counsel. I'm a proxy counsel in this matter.
Uh,
Instead of 4 and 9, it has become 4 to 9 minutes to carry out the paper.
Petition shall carry out the, permitted to carry out the corrections in the application filed for substituted service.
Please, ma'am.
You want to take, do it tomorrow, let it come tomorrow, 13.
Please, ma'am.
Give him, he'll carry out the correction.
Please, interim order may be extended.
Look at it. Yes, 14.
I'm for the petitioner in this matter. Petitioner died on 1/1/2025. I filed the application to bring the LRs on record.
Who died?
Petitioner himself died.
Petitioner died.
Yes.
Yes, IA number 1 of 25 is filed to bring the alerts of the deceased petitioner on record. Accordingly, the IA is ordered and the petitioner should carry out the amendment to the cost title. Then what about IA for substituted?
The application is allowed, then I'll have to file the application.
No.
Some time may kind of.
For filing the application for substituted service, 2 weeks time is granted.
Yes.
I appear for the petitioners in this matter. And ask me.
But this may require
Collect
some
clauses.
time, my lord. So it may be taken up any other date.
Wednesday,
Please, ma'am.
at the request of counsel, the petitioner. Yes, 16.
Filed an application to recall the order of dismissal, my lords.
Hmm.
The order of
Last occasion, your lordship said, my lord.
the injunction order is operating, keeping open the injunction, a suit shall be disposed. So that is the only submission is made.
My application to recall may be allowed and a direction may be passed to dispose of the suit within a period of 6 months, madam.
Please,
Tomorrow we'll do it. I have a meeting.
please.
Indeed, madam.
All the matters, let it come tomorrow. Tomorrow. All the matters, wherever there is interim order, that will be extended. Apart from that, if you want to make a mention, make a mention.
Serial number 23, impugned
Which
order.
number?
Serial number 23.
Court officer.
Impugned order is in Kannada language. May have it on next week. madam.
23, list this
Tomorrow.
matter on 11th of March. Next,
My lord, serial number 29, not tomorrow, Monday, your lordship may have it.
Tomorrow is, my lord, the half day. It may not reach again. Tomorrow is half day.
29 on on 4th of March.
Much obliged.
Serial number 32 of list number 2, my lord. Posted on Monday, my lord, for dismissal.
Why?
Still,
My lord, I'm the respondent. Yesterday I had made submissions. The petition has become influx.
No, why it should be posted for dismissal now? Yes,
List 224, so.
Monday, yes.
Monday, my lord.
Serial number 30.
30.
Kindly have it, serial number 33, list number 2.
Hmm.
It's only on the point of law section 6, madam. Kindly have it on the 6th, 7th, 6th or 7th.
6th.
24th, my lord, serial number. List 2, serial number 24, so me.
Okay. Huh?
24, my lords, list 2. My lords may grant me a week's time in that. Just came to know that the objections were not filed. The senior counsel on record had passed away. So 1 week's time I'll file them.
At this point of time, without the other side, you can't make a mention like that. It can be adjourned. Let's just matter on 11th of March, 24th.
Please.
At the request of counsel, the petitioner.
Please, my
Yes,
lords.
next.
Highly obliged.
Serial number 25, list 2, placed for 3 weeks adjournment, madam.
Why?
Senior is contesting for AAB elections. He will not be available for.
Can that be a reason for asking adjournment?
Please.
That can't be a reason. Yes.
Serial number 21, my lord, any
Let it come, come tomorrow. Yes.
Serial number 21, my
Oh.
list 2, next week.
Why?
It's coming up on a daily basis.
21 lists is matter.
Any
It
day
is?
next week.
What did you say? It is
So
coming.
it was posted yesterday, it is posted today, my lord.
So you don't want it
No,
to
my
be
lord,
tomorrow?
there's some inconvenience, ma'am.
Then what is that submission? Post on 3rd of March.
Much obliged.
Yes.
My lord, the lordship posted
Lord
on
of
4th March, my lord, or February.
March. Any adjournment on March?
My lord, the earlier date I wanted, my lord,
Which is your case?
18, my lord,
18, let it come on 5th February.
17, my lord, tomorrow,
17th?
17, my lord.
It will come tomorrow. Whoever are not mentioning, it will come tomorrow.
My lord, 21st March is a long date, my lord. Next week, any date.
You can't have the cake and eat it too. Not as per your convenience, matters will come.
Tomorrow, my lord.
Let it be.
Much obliged. 21.
All other matters, let it come tomorrow.
Madam.
ನಾಳೆ